Everybody's doing well on this fine Thursday morning, July 31st, 2025. Boy, it's hard to believe it's the last day of July, isn't it? Jeez, years flying by. All right, well, welcome everybody. Good to see y'all. So we'll get started on today's work session agenda. And the first item we have is community redevelopment areas.
So Rebecca's on her way up, but Commissioners, you asked to see all of the different CRAs, when they're expiring, and really go through the CRA process and where we're at on all of them together. So they put together a good presentation here that kind of outlines that. This is a follow-up to our previous CRA discussion. And so with that, I'll turn it over and let her get going.
Thank you. Excuse me. Thank you. Good morning. Rebecca Stonefield with Housing and Community Development. And as was just mentioned, a couple months ago, we had come forward with an application for a CRA in Tarpon Springs. And there were a number of different questions that came up, and we're hoping to excuse me, address those today. And so primarily what I'm going to walk through is give a little bit of background of how we got to today's CRA policy for the county, when is it applicable, and some key points of that process of utilizing the policy. And then I'm going to give some snapshots and some information about the existing CRA program in the county for some of the different CRAs, and hopefully be able to answer any questions that you may have. So, excuse me, so back in the 1980s is when the county started seeing its initial community redevelopment areas get established. And this was in line with state statutes. Prior to 2002, in the 80s and the 90s, the CRAs that were established were primarily guided by what was deemed blight as per state statute, but the way the county would tend to oversee them or evaluate them was really attributable on an individual basis by CRA, what was in their specific ordinance. There wasn't necessarily a consistent process by which we would establish CRAs. When it got to, prior to 2002, the types of things that were focused on were more in the traditional downtown areas, not necessarily looking at conditions outside of those areas, dealt with a lot of physical improvements, things like that. And then when we got past 2002, other things like economic mobility of residents and things like that were also being considered. And then in 2016 is when we got direction from the board to say, we need to look at a consistent way we are going to determine not only do we establish a CRA, a new CRA, but at what funding level, what type of need is there, what would the county be willing to help assist with through a funding mechanism. So it was in 2017, 2018 that the first kind of current version that is what today's policy is akin to was kind of created and moved forward. And we worked with a third-party consultant to establish that a scoring methodology by which we could evaluate that based on not only what are the requirements of the state statute that determines is this area in need, but other socioeconomic factors that were important to the county, other physical conditions of a community, safety conditions of a community, and so forth. And then in 2021, which is the current policy that we implement, again, is very similar to that 2018 version. However, we minimized, and I'll walk through a number of these things on future slides, but we lowered the maximum lifespan of a CRA from even the 2018 version, and we focused the types of expenditures that we thought were valid for county TIF funding based around what the policy outlines as county priorities. So again, what we have in place today, we have the need for certain performance goals to be met as CRAs are evaluated. We look at, we wanted to also correct something that had happened in the past where sometimes the county was contributing more to a CRA than the city was, so that's corrected through this policy. That when we establish new CRAs or we're at the point where we can make adjustments, we will in fact ensure that the county contribution would not be higher than the city's. The other thing again is that we're really focusing on that contribution being associated with things that the county wanted to achieve as well. So this is a slide that gives you a snapshot, and I'll walk you through this a little bit. So that first column referred to a CRA type. That is what we refer to as a local designation of CRA. So when you are looking at establishing a CRA, or it's at a point where there's some sort of evaluation for adjustment, there is a scoring methodology looking at, again, a bunch of socioeconomic factors, physical conditions of the area, are they in a coastal high hazard area, things to that nature. The highest level of need is identified by that urban revitalization category. There are widespread, maybe endemic type things that need to be addressed, down to the lowest level of economic development, which is maybe there's not a widespread issue, but there's certainly demonstration that there are locations where we'd want to focus additional investment. And really what we're talking about when we're utilizing a trust fund for a CRA is how do we target and focus public investment to help spur private investment in that area? How can you improve the area that would draw private investment? And that's what the long-term hope is for the success of CRAs. So state statute prior to 2002 said a CRA could be in existence for up to 60 years. And so even if the county established it at, say, 30 years as an initial CRA, 30 or 40, the CRA would have the opportunity to come back and say, I'd like to extend, as long as they never exceeded that 60-year mark. After 2002, the state amended that to 40 years. However, with direction of the board and the understanding of our own priorities, we wanted to be a little bit even more restrictive on what that term would be. So it would be the maximum a new CRA could be established at would be 20 years. Again, there's always opportunity where they could come back and ask for an additional amount of time, but not to exceed 40 years. But we would never exceed 20 at initial establishment under this policy. And you can see that if you're at that lowest tier of economic development, that would be no more than 10 years. So the next column, which is what the base county contribution would be. And so utilizing that scoring methodology, there's a point system associated with that helps guide that classification, and then what the minimum base contribution the county, if a trust fund is established, what is the minimum amount the county would provide for, based on TIF revenues. The tax increment financing is what is the key tool that the state statute aligns with CRAs. The state statute also says that if a trust fund is established, you can't be below that 50% mark. At least 50% would have to be provided. For our highest level category in our policy, we're saying that base value would be 70%. And then there's the opportunity for a county priority match for the county's contribution. And what the policy suggests is if there is a commitment as identified in the CRA budget that a certain percentage of that, and I believe it's a minimum of 50% of that budget, is going towards what we've identified as county priorities through the policy, then they could get up to an additional 25% at that middle and high level contribution. So that's how you get to the max total of the 95 to 75% at those two classifications. And this is just a snapshot of the types of projects, or the kind of the high level types of projects that we are saying county TIF funds could go towards if it's in alignment with county priority. And those three broad categories, of course, are housing affordability, mobility, so looking at things as walkability of a community, are there improvements that are needed to support transit, those types of things. And then, of course, job creation and economic development or employment, which are some of those factors that we look at in the scoring. And there's a focus on the physical capital type project. Planning for those could be costs associated with getting a site ready for development, things like that. And then there are opportunities for more programmatic funding of programs. But all of these projects and programs that would be identified in an approved redevelopment plan that would have to come before the board for approval for a specific CRA, all of the funding of the projects would have to be in alignment with that approved plan. The next few slides are looking at our specific CRAs in the county. There's a lot of information here. On the next couple slides, I'll focus on a few things for each of the CRAs, but what I wanted to illustrate through this slide specifically are two things. You can see that approximately half of the existing CRAs are going to sunset by 2034, 2036. And then the other half go a bit beyond that, and I'll touch on that on the next couple of slides. You can also see from here, and this is based on the fiscal year 23-24 payment, that about $24.5 million during that year is what we paid to all of our CRAs. That's the full payout to all of our CRAs for that fiscal year. That's based on that's the actual payment, and I believe that there's an update to that, and it's a few million over that for fiscal year 25. So it's not that far off there. So on these next couple slides, I wanted to break it down by the county contribution per the individual CRA. And so what you're seeing here also, 5 out of 7 of the CRAs that are at that highest contribution level, that 95% contribution level, will be sunset by 2034. And then those last two, the Clearwater North Greenwood, which is one of our more recent approved CRAs, and Lellman, which is our only CRA within unincorporated county. While those don't sunset until 2043 and 6 respectively, you can see that there's a midterm review scheduled for early 2030s where it would come back. We'd have to evaluate their progress. We'd have to understand how county funds had been spent to date, what successes have occurred, and there is the potential opportunity to adjust the TIF at that point if we feel that that level of contribution is no longer appropriate. What I didn't identify in the last slide, and I'll just highlight here, is any of the CRAs that are in yellow indicates that there's language in the specific CRA's ordinance that says if there is indebtedness associated with the TIF contribution for that CRA, we don't have the ability to lower that TIF or adjust that TIF, but that's only if debt is in place. And on this slide, I don't believe either Largo, West Bay Drive, or Lellman has any debt in place at this point in time, but that would be evaluated at midterm to determine if we have the ability to potentially adjust that, if appropriate. And so these next two tables are just the remainder of our existing CRAs that have a TIF associated with them. So Pinellas Park and the expansion area, and then also South St. Pete have a similar situation. While they may not expire till a little bit later, there is the opportunity much earlier on for that midpoint review. And then these last two CRAs, Safety Harbor and St. Pete in Town, are the CRAs that are at our lowest level of contribution, our 50% of contribution, and both of which are set to sunset in 2032. And that's my presentation, but I will try to answer any questions that you may have.
Questions? Commissioner Flowers.
Thank you, Mr. Chair. Thank you for this presentation and the information because it makes things a little bit more clear for me because we have so many that operate the way that they should. So I just have a couple of questions. We have a really good time updating our strategic plan. Some of the things remain the same. Some of them have different benchmarks. When we are updating our strategic plan, does that have any effect on the CRAs that are in current progress for projects that have not yet been identified but could potentially be identified before the ending of their CRA term?
Two-part answer. Technically, no. There are the CRAs that are in place have their approvals tied to their ordinance and their resolution and the redevelopment plan that had been adopted. However, if they are coming back for probably an amendment or at their midpoint review, at that point, I think it would be appropriate to say, is this in line? Is our policy still in line with our what we're trying to achieve? And therefore, how can we make sure that any adjustments that are made are also in line? And what I'll say is that, again, projects that they undertake that they use TIF revenues for have to be identified or associated with the redevelopment plan. So anything outside of that would not be permissible to use those funds for.
Thank you. My other question is, for the South St. Pete CRA, that was a little different model. Yeah, very different. And I wasn't here then, but I didn't like that model. Because it wasn't working, and I don't believe it's working now. So the model doesn't just look at economic development or the business piece, it looks at the human piece.
people-based.
And that's where
Yeah.
the rub is. And so I have observed some of what the CRA should be doing in South St. Pete, but I also see where some of the dollars are helping entities who have that capacity on their own, and those entities who really are struggling aren't able to get the financial support. So my suggestion is we not do that anymore, make that consideration anymore for, keep CRAs the way that we have them modeled and outlined, because it seems like they work better that way and are better utilized that way by all potential business entities within that CRA versus the model that they have right now. So that's mine on that one. And I've said this when Mayor Kreisman was in office, I hated that, the way that was done. But that wasn't, y'all's
No, I'm just, that's the first I've heard that strong of comments regarding that Southside CRA. But Rebecca, is North Greenwood, is that also people-based?
They are,
I thought they were
they're
more
subject to
economic
the current
development based.
policy. Yeah, they think they were established after this current policy came into.
Yeah, they were more economic development based.
Okay.
Yeah.
I just want to clarify because
Oh, you can
because
pull
I don't
up some
remember.
articles, you can read where the CRA, there
Yeah.
was issues with because they have their own CRA board, like we
Correct,
suggested.
yeah.
And there were just concerns even within that, and then some of the projects that were being submitted by that board to the administration for recommendation for assistance, and, going through the vetting process and all of that good stuff. And then when it got to administration, those are not the projects that were selected. Other projects came up. And so why have a process where that you have to go through based on the standards that have been set, but then you just completely dismiss them? So it was a lot of, and you may not have heard, but anyway, I got an earful.
The one thing I might want to add is that we do look at their spending on an annual basis, and we do make sure they identify where in the plan certain projects are identified, so we know money is being spent on something consistent with the plan and so forth. So we do have the opportunity to at least look at how spending is happening on an annual basis.
Okay. And then I talked briefly with Barry about this. So if we have a project where we have approved the CRA, but then the guise under which we approved that CRA is not the same, it's my understanding from Barry, that those funds don't go forward because the project that was requested, which is how that CRA got approved, isn't moving forward. So
I've asked the county attorney's office to take a look at that.
take a
so-
look at that. Okay, thank you. So I won't say anymore because I don't want to.
Yeah, yes,
Okay.
please.
Thank you. I appreciate that. That's it.
All right. Commissioner Eggers.
Yeah, thank you for summary of kind of where we're at in the process. So I think I'm not, no secret from my perspective that I think CRAs have been good for Pinellas County, period. We entrusted and created a partnership and relationship with the different cities and now an unincorporated area to say, what your community needs. I like the balancing piece so that they're investing the same towards that effort. But if you take a look at some of the stories, success stories around the county, I think they've been really good. I like the midterm check-in. I think that's important just to make sure everybody is on board with it. As it relates to capital, and you talked about capital that's got debt tied to it, having a requirement for us to acknowledge that. I just want to make sure I understood that piece again.
So how the debt plays into those with the ordinance?
Well, because whether it's debt or it's capital, to me, there's a commitment. So maybe they're not debting it. Maybe they're not getting a bond for it. They're paying for it themselves with CRA funds. So I don't distinguish the difference, but I just want to make sure I understood.
So this is really based on ordinance language for specific CRAs. So if there was something that was called out in a specific CRA's ordinance saying, in this scenario, the county is not going to be adjusting that TIF because there is a distinction made in that way. But if the county opts to take on new CRAs on a case-by-case basis, or however we opt to proceed, if a new ordinance is created, we can certainly make sure the correct limitations are established within the for the individual CRA.
The other thing is when, and this probably dates back to when I was at the city of Dunedin, and I remember the discussion about there being 14 criteria for the establishment of CRAs, and you have to have at least 2 to move forward on that. Are those criteria still in place in the state statute and what we have to kind of go by?
Yes, all of those, well, I can't say exactly from the year exactly how it matches up, but there is still a whole list of criteria that the state statute identifies. And what we've done with our policy is incorporated those and then added to them other things that we wanted to look at, cost-burdened housing, again, if there are locational challenges, things like that. So the things that you note that were in the state statute are still part of our analysis.
So when we add so when we're looking at the base county contribution, I'm assuming that takes into account
That's correct.
that analysis.
That's correct.
And then when we're talking about the priority match, there's some additional things that we would just like to see that maybe aren't in that 14 criteria.
The priority match is more based on the commitment of the city's CRA funds to go to specific priorities that are outlined in the policy. So if they're saying a certain portion of our budget is going to be committed to housing affordability or projects that will improve the infrastructure or things like that that are in line, again, with the plan, with our policy, et cetera, then the board could consider upping the percentage towards that cap. So
Could you send us that list of 14 criteria?
Absolutely.
Again, I'd like to just see how that lines up as it relates to the things that we have added to it. 'Cause
Absolutely.
it seems to me that most everything is in that 14, those 14 criteria for us to consider versus having a priority match. So, all right. So just as, again, a reminder that the total taxes that are generated here is not a tax increase. These TIF dollars are exactly that. They're incremental that would be there coming to us versus going to the city. So when I remember, like, we got a lot of feedback earlier and when I was in Dunedin about a tax increase. And it really isn't. It's a tax income, I guess, distribution change. You know, instead of going to the county, the cities are doing it. But if we go back in time and you look at the improvements that have been done, or the issues that we had with a lot of these cities, and they said, hey, there's a way we can really bolster not only the places for our tourists to come visit. I guarantee you that if Dunedin looked like it did in 1990, that the tourism dollars being generated not only for the county but for the for the city wouldn't be nowhere near it. So they've tried to improve that community base for a lot of reasons. I'm not so sure as much on I think there was like 2 or 3 of the 14 criteria that were met, critical ones, but nonetheless, it wasn't 11 or 12.
Right.
Anyway, just trying to circle back to what I think is important about them, but at the same time, that's why I was saying, I want to slow the growth of government in Pinellas County, and so if we get monies that are, and that's why I wanted to see that flow of cash coming back to the county and when it's going to happen, so we could start making some plans for us here. I mean, we just talked earlier about if we could find $25 million, what that would do for our own millage rate, for instance. So I mean, those are significant dollars that we can plan for as we look out. So anyway, just a few comments, but I appreciate it. Thank you.
Yes, thank you, Chair. Rebecca, the state allows us to create these CRAs. Does the state law regulate the policy conditions that we can use to evaluate whether we want to approve one? Are we limited on what we can and can't consider?
No, we can't be in conflict with them. We can't go outside of some of the parameters, but we are allowed to hone in on county priorities or things that we think are appropriate for the county, as long as it doesn't conflict with what the state statute would say.
And you're not obligated.
Not obligated.
Just because they meet the criteria, it's still the commission decision.
Yeah.
Okay.
So, but you can add to it, but they have to meet the minimum state requirements, but you have the option to add criteria, like she said, as long as it's not in conflict.
Okay, so we can add criteria.
You can add criteria, and you're not obligated to approve any of them.
Okay. Is one of our criteria, you said we had 14 criteria, is that what I heard, Dave?
I don't know the number. I think what Commissioner Eggers was referring to is that in the state statute, they list probably about 14 things to determine if an area is in need, and we've added to that.
Is the land use and the zoning allowable at in the areas, the CRA, is that something that we consider?
That's not something we consider as far as whether or not, I don't believe we've considered that in the past, other than to say any redevelopment plan that a specific CRA brings forward would have to make sure that the implementation mechanisms were in place.
Yeah, I just think it would be good to I mean, if the idea is to promote growth and promote revitalization of an area, we should at least be able to say, you know, your land use and your zoning needs to be changed before we'll approve this, because it'll hinder the growth or revitalization in the area.
In some way,
Parkland, for instance.
Yeah,
If we
right.
couldn't build on it, why would we be funding?
Right.
but they do have to submit a plan.
They have to submit a plan.
So that you have to approve the plan that they're going to use the money for. So in that way, you're going to see not necessarily the zoning, but the types of activity that you're
Right.
supporting, because that would have to be in the plan,
I'd
correct?
just like it to be clear that the zoning, the land use will allow the redevelopment, supports it. Yeah, something we should be considering.
I see.
And then, if we do that, then are we allowed to put conditions on the approval? Like, say the city goes and we say, oh, this land use plan works, this zoning works, it's going to be great. And then 2 years later, they go, we're changing our zoning for this area. Can we rescind the CRA if they change the plan on us?
Yes, if for any plan amendment, it comes back to the board. They would have to review that. At the local land use and zoning level, that would happen that would not necessarily come back to the board, but any projects would still have to align with the types of projects that you've approved within the plan.
Okay. I appreciate that.
Yeah, if I could just, for just a few things to clarify. Since Pinellas County is a charter county, we are given greater powers under the Redevelopment Act than a non-charter county. So the reason why the municipalities come to the county is because of a statute in place that requires, basically the cities have to come to us to ask for delegation to undertake all of the powers that are otherwise granted under the Community Redevelopment Act. Our neighbors to the north, Pasco County, do not have that same kind of control. The cities can do whatever they like up there. So what we've typically done here over the years is when the Board of County Commissioners passes a resolution delegating that authority to a municipality, Pinellas has typically done a limited delegation. So delegated some powers, but not others, for instance. Many years ago, there was a bit of a controversy in Florida about the use of eminent domain within community redevelopment areas. Pinellas County never delegated that authority to the cities in this county. So you do have that authority through your initial delegation. Zoning and land use are completely unrelated to these community redevelopment acts by virtue of the statute. That's not to say that there can't be some interplay. There's going to be some interplay. Just to give you guys an idea, I know we've talked about some of the criteria, But, here it says, you want to prevent and eliminate slums. You look at, dealing with traffic patterns. I know that some of the criteria in the statute, and forgive me, I don't have it right in front of me, talks about, outdated roadway grids, higher levels of code enforcement within that area. So the criteria in the statute really do get at blighted and slum areas. So for instance, you're not going to have an area that's a park that would qualify. It just simply wouldn't qualify. But in part of what, and Rebecca's done a great job summarizing a lot of things, and in looking at some of the delegating resolutions and interlocal agreements that the county has over the years, we've definitely gotten tighter about putting more controls around these things. For instance, anything that gets bonded, if it's using county TIF, has to come back to the county for approval. And I'm sure that the staff and planning is keeping an eye on that through that annual review of things. And the bonds are really some of the limitations that we have as far as potentially being able to rescind delegations. Because you do have ordinances for all of these things that make certain agreements. You have interlocal agreements for many of them that enter into agreements with the cities. So a lot going on here, but just kind of wanted to throw out a couple things and highlight too that we have some of the rights that we do here because we're a charter county.
If the bonding extends out beyond the length of the CRA, does that affect, I mean, if it comes to the end of the CRA, our contribution stops, even though the bonding may go on. How does?
I will say I'm not a bond expert, but I would be surprised if there were bonds that went beyond that because the bonds have to be secured with some sort of a revenue stream. And it cannot be general ad valorem tax dollars. To secure bonds with general ad valorem tax dollars, your local governments are required to have a referendum.
But they could use their own TIF dollars for that.
Their own TIF dollars, sure, if that's what was pledged, if that's
Right,
what was
right,
pledged.
I understand, yeah.
Sure.
I mean, they could just separate, these are pledged to here, and the county ones are pledged to other stuff.
Sure.
And then when that runs out, we still have the match.
Sure, and for instance, it's not going to happen now, but in the St. Pete in-town agreement, they had, in the latest agreement that the county and city entered into, there was a good bit of money set aside for city TIF only to fund some ballpark, renovations. So we do have agreements that very clearly separate the city versus the county dollars, and we always require that they be accounted for separately. So we do have a pretty good track of the funds that are being expended. So yeah, I mean, there would be bonds out there that could be city TIF only, and we were expecting that, in the in-town.
And every year we get an annual report of the CRA, the financials, the commitments, and all of that wrapped in. And it usually shows up under our part in the very beginning. So if people want to take a look at it, that's when you do it. So, okay, thank you.
Okay, I've got a question. So just CRA 101. So a CRA is established at the 50% level, let's say. So does that mean from that moment going forward that 50% of the county taxes collected in that area then go towards that, or is it just on the increase in value over time?
Just in the increase from the year, is what's referred to as the base year, the year the CRA was established, the difference between that base year and that current year, that taxable value, that's what it would be based off of.
And then the municipality contributes the same, correct?
Correct.
Okay, so even if then there's an additional county match, does the municipality have to match it like dollar for dollar?
It's, there, I believe, I'd have to look at the actual methodology, but there is a commitment of their funds towards the same projects, types of projects. But the county contribution would never be more than the city's for the new CRAs.
Got it, okay. All right. Thank you. Any other questions?
All of those, yeah, are all those monies from the very beginning, depending on when they started,
Right.
are still coming, the county portion's still coming to the county. It's that little piece, that incremental
The original,
tax
the
that
base year
is
is,
above the base year, everything above, so it's all tax increment financing. And so some of them, like, again, back to Dunedin was back in 1990, so its base was pretty low compared to where it is now. So when that comes due, you know, in, what is it, 7 more years? I know there's.
There'll be a
there's-
lot coming back to the
Yeah,
county.
that whole TIF piece on the county dollars, it comes right back to us, so. It's,
And Commissioners, I think this chart really calls out what you were asking for the last time, which is, you know, when can you count on some of that money coming back, and therefore being able to make some decisions regarding how to, you know, manage that additional revenue.
But roughly 25 million-ish a year is what the county's contributions is.
Correct.
I think it may have been a little bit higher, and we work with OMB on an annual basis to understand those numbers.
So, for example, then on Oldsmar, sunset year is 26. So in the 27 budget that we do next year,
Correct.
those funds will be back in the general fund dollars.
476.
Right.
Yes.
Yeah,
Mhm.
okay. And so that's the reason for getting an idea here, when those funds will start coming back and what amounts. And it'll also kind of justify some of those dollars that we've diverted from county funds to investment in our, and we have 24 of those cities that have done different kinds of investments. So-
Correct. And now assuming that it worked like it's supposed to, it created value. Now that they've added that value and it's operating on its own, the private investment's coming. Now, as you begin to roll some of these off, you can see between 2030 and 2030, you know, 4, 6, right there, potentially you have a significant amount. There may be some that'll come back and ask for an extension, and you'll have to make that decision at that time. You know, and so, but that's the opportunity to have some of those discussions and look at evaluate not only the TIF, but also, you know, the contribution levels.
And I think it's important what Commissioner Scheer was talking about, that the development potential of a CRA is pretty important. One of the concepts that is hard for some folks to gather over time and just looking at it, when that value is going up each year, that's one bit of increase. But when you have an environment that is fertile for development, those new tax dollars are brand new. I mean, you go from, you know, 0 to, you know, it's not that 3% increase or 5% increase. It's a huge, and that's the reason for these favorable development patterns that you look for in CRAs to really bolster that tax base. I mean, it's not just that little incremental increase or that little CPI increase or whatever. It's new projects on dirt. It's huge. And so that's why some of these numbers that you see here, I mean, they're pretty significant, the ones that will be coming back. So anyway, thank you.
All right, thank you very much. Okay.
And,
Okay, so now we'll move on to our noise regulation update.
So Kevin and Jude's coming up. We're going to talk about our noise regulations, but while they're walking up, I figured while we're talking about planning stuff, welcome Greg Mims back there. He's our new planning director, so he's on his 4th day, so I didn't think he should give the CRA presentation just yet. But we want to welcome Greg to the team. Greg, wave right there. So Greg's the new planning director, so 4th day on the job. He formerly was a Indian Rocks Beach City manager, and he's come to join our team, and so
Welcome.
we welcome him. He's got a good development background, and so more things to come on that. But with that, I'll turn it over to Kevin and
Thank you, Marion. Good morning. Good morning, Mr. Chair, Commissioners. Kevin McAndrew, Director of Building and Development Review Services. Jude Reason, our Code Enforcement Division Manager and Housing Official, is going to lead our presentation this morning. I want to preface the presentation, though, with just a couple of context remarks. And at the direction of this board, our code enforcement team has worked very closely with the county attorney's office over the past several months in looking at all aspects of our noise ordinance. And I want to thank Jewel and her team specifically for their expertise and guidance in bringing us where we are today with a suite of recommendations to update our noise ordinance. You know, regulating and enforcing noise brings with it a set of unique challenges and constraints, from the technical complexities of obtaining accurate noise measurements and readings, to dealing with response time, to dealing with noise complaints affidavits, affected parties, constitutional considerations, and how to prosecute violations most effectively. So the updates and recommendations that we're bringing to you today include a whole set of addressing what I'm going to refer to as ambiguities in our current code, addressing those to have a clearer regulation that's going to help enforcement, and also expanding the tools, most importantly, for our code enforcement team to more effectively regulate noise in the unincorporated county. So with that, Jude.
Good morning, Commissioners, Chair. Thank you for having me today. As Kevin said, I'm Jude Reason, Pinellas County Housing Official. I oversee the Code Enforcement Division. Today we do have a very brief presentation about some of the updates that we have worked on collectively with the County Attorney's Office, as well as the Sheriff's Office and our Code Enforcement team, and taking into consideration some citizen feedback. The proposed revisions ensure continuity, as Kevin said, with state, federal, local laws, as well as some constitutional considerations that the County Attorney's Office helped us navigate. So thank you for that. But perhaps most importantly, they also ensure equity amongst our citizens, our community business partners, and those that are affected by noise. Just jump right in. So the first thing we had to do is update some of the definitions and or bring in definitions that we didn't have prior. And these are more in line, again, with our governing statute, Florida 162, which requires some of these to be in there in order for us to move forward. One of the biggest ones we put in is the itinerant or transient. This refers to excessive or disruptive noise that comes from a source that's either moving or temporary. This allows us to kind of roll into the second definition, which is irreparable and irreversible. So the two can be interchanged. And basically what this does for us is it allows us to identify noise that's very temporary in nature and can't be undone. Basically the damage has already occurred. It's already woken up neighbors. We have to get it addressed, and we need to come up with some sort of enforcement process to address something that we aren't there to actually see happen, which goes into loud and ruckus noise. Loud and ruckus noise is noise that's made can be itinerant or transient, irreparable or irreversible, and typically happens during quiet hours. Specifically in the ordinance, it is during quiet hours. So this is any time that is defined by the quiet hours section, which is next, which the county already had. We just defined the term and specified the times that were already in there. Quiet hours has always been from 11 p.m. to 7 a.m., Monday through Saturday, and then all day on Sunday. There is some areas in our ordinances or in the code that speak to alternative quiet hours, which we've addressed in here. So there's a couple other sections where it may be outside of the noise ordinance, and that's typically going to be more restrictive than what the noise ordinance currently allows.
Jude?
Yes, sir.
So like maintenance of our grass areas, like we don't do that on the weekend or on Sundays. We don't have our medians being mowed. But what about private companies that have kind of historically been Monday through Saturday, but every once in a while they'll kind of creep out on Sunday? Technically in the unincorporated, this is all unincorporated, they would be in violation in that case if they're out doing it in well, they're noisy anyway, so.
Absolutely, and in fact, as we go through, we actually address that a little bit further down the line. But we did come up with a revision that now allows us to have a little bit more enforcement authority to regulate that.
Sorry about that. I guess if I'd been patient, I would have gotten
That's
that.
okay. Yeah, we're almost there. It's a very brief slideshow here, so we'll get there in just a minute. We had to update the general prohibitions. And these, again, are the, I'm sorry, we'll go into the first one, which is the use of an amplifier or loudspeaker for advertising purposes to attract the attention of the public. So that's an addition to the general prohibitions. Additionally, the factors of whether or not a noise is itinerant and transient in nature, which was previously discussed, or if the violation is considered irreparable and irreversible. So these had to be added in to go hand in hand with the definition as we go through the enforcement process. Well, loud and ruckus was updated. We always had a provision for loud and ruckus, but we have updated, redefined it, and really honed in on some of the concerns that we have from our citizens. First and foremost, again, prohibited during quiet hours. But we have added yelling, shouting, whistling, singing, or other noise consistent with parties or gatherings or used to attract attention. This has been on the forefront of a lot of complaints that we've received recently. Also, this helps us navigate the court system a little easier because specifically not having this definition in there or this criteria in there, the judges had been dismissing our cases. So now we're adding this in, and we're hopeful that the judges will accept this and move forward with our enforcement. Commissioner Eggers, as you stated, operating mechanical equipment, which disturbs peace, quiet of a reasonable person during quiet hours in residential zones. Same thing that you just addressed. This is during quiet hours, people that are operating lawnmowers. You may have the continuous neighbor that's remodeling their home till 2 a.m. Those factors are now going to be in the ordinance, and we can move forward with enforcing those.
So if somebody on Sunday afternoon is running into this problem, who do they call?
So if it's a continued problem, they would certainly want to give us a call. And what we will do is we'll take in the complaint through our standard ordinance, our standard enforcement process. We'll evaluate their complaint, what they have brought in, which we're going to kind of roll into how they do that here momentarily. And if it does in line with the facts, circumstances, and evidence, then we can move forward with an enforcement case. And typically, these are something that's kind of a prolonged with a higher probability of detection. They can also contact the sheriff's office if it's a problem that's happening right in the moment and they need it to stop fairly quickly. That's usually the first people that get called to the sheriff's office because they're there within moments, and the sheriff tends to deal with the person who's making that noise right then and there. For us, we typically deal with the owner of the property. So a lot of our stuff is after the fact, but we tend to carry a little bit more weight in what our...
Yeah, that's an area that I think you have a lot of new companies coming into play. They may not even be aware of the fact that you can't be out on Sunday. They would realize at 7 a.m. for sure, but the Sunday thing is a different thing. So when Commissioner Scott's out golfing on Sunday morning and he yells 4 because he's, does that count too? I mean,
itinerant and transient.
not that you ever have to yell 4, but I think, the ones that go off into the street, into the neighborhoods.
I have no idea what you're talking about.
Okay. Got it.
And we'll get into the enforcement aspect of that in a second here.
Jude, I've got a quick question.
Yes, sir.
Wasn't the quiet hours, didn't that start at 10 p.m.?
So they vary based on where they are in the ordinance. So we have an ordinance, a short-term rental ordinance, for example, has a designated quiet hour that starts at 10 p.m. So it is more restrictive than the noise ordinance in which it would apply in that case. We also have some other areas regarding outdoor music, amplified music, areas that serve alcohol and so forth. There's a few other sections that require those quiet hours that to be a little different than the standard for the rest of the county.
Got it. Okay, thanks. Good question.
So the noise complaint updates, this was a very, very big update for us. Previously, we required 2 affidavits from a citizen who heard a noise and wanted it to stop and file a complaint. This would have had to happen from a citizen on each side of the property or 2 affected citizens. They had to hear the same noise at the same time and be complaining about the same property and then sign an affidavit, which they would send to us. Following that, we would send a 7-day notice of violation pursuant to ordinance, which basically meant they had to turn down the music within 7 days. We found that to be a little kind of unacceptable. So we have changed it to 1 affidavit from an affected party, which is another element of the update in the noise ordinance. We have limited noise complaints to those who are actually affected by the complaint. So if you have somebody from the other end of town calling in about somebody from the south end of town, that wouldn't go over. They're not actually affected by it. It's not a valid complaint. But now we can do it with 1. So this mostly is going to adhere to loud and ruckus noise. This is when we're not available to actually listen to the noise that's occurring. Again, it's probably going to be that itinerant or transient in nature. This will allow a citizen to actually fill out an affidavit, a statement. It'll require them to appear in court, testify, and that's going to also be coupled with whatever evidence they bring to the table to help substantiate that complaint. We will certainly need that. We can't be in a he said, she said situation. So a citizen that does want to do that is going to have to provide some commitment and again, evidence, which had been previously addressed in some of our other meetings where citizens have been wanting to turn in recordings or videos that they might have to offer that. Additionally, the sheriff's office is able to provide us with the same information. They can provide us with body cam footage, as well as a statement from, and a report from the deputy, responding deputy. And we can take that information and use it to hold the homeowner accountable for that noise. Not all noise is caused by homeowners. Sometimes there's renters or other transient folks in these homes that are creating these noises. So the sheriff's office can identify that, work with them right there on the spot, usually typically within minutes of a phone call. But we will then later use that information to hold the homeowner accountable with, it can be notices. We can also go directly to a citation using some of the new rules that we have. So itinerant and transient nature, irreparable and irreversible, will no longer require a notice of violation and a time to stop the noise or reduce the noise. We can actually go directly to a citation or a hearing where a magistrate or a judge can hear the case and assess a penalty for what can't be undone. So that's another element that we added to this, which I think is going to give us a lot more enforcement capability to hold those folks responsible. We made some very minor adjustments in construction noise, both which kind of benefit everyone. One, we just updated the quiet hours, and we use the term quiet hours in there instead of the designated time that was already in there. The times themselves haven't changed, just the term quiet hours has changed. Additionally, we have always had the ability to issue a waiver for construction in residential areas when it's absolutely pertinent, but our previous ordinance, or the current ordinance, is a little counterproductive on how we do that. So we went ahead and cleaned that up, added some additional verbiage in there so that we can issue a waiver whenever it's necessary. Occasionally, we have construction companies that have to do, I'll use this as an example, concrete pours at night. Based on time of day, their interaction with traffic. Even our own public works department has reached out to us for waivers because they're doing road work within a residential area, and they want to make sure they're not going to get complained on and they're legal. So we've cleaned that up, made it a little bit easier for us to be able to lawfully issue those waivers in those extenuating circumstances. Doesn't happen all the time, it's fairly rare, but we want to be able to do that lawfully in case the sheriff's office gets called out in the middle of the night on some of these folks. And that's it. We hope to bring this to you sometime in September. If you like what you see, obviously we would love any recommendations or feedback or any questions.
Commissioner Flowers, first. I'm sorry. I'm sorry.
Thank you for that presentation. And thank you for the clarification as it relates to the short-term rentals. I don't know why I thought, though, that we wanted to make it consistent across the board for the 10 o'clock time. That just keeps ringing in my mind that we had discussed that. Perhaps that's not where we landed, but I thought that in order to be consistent across the board, so it wouldn't be any confusion, I thought we had entertained 10 o'clock instead of 11 to 7. But if, again, that just could be my memory and it's wrong.
It's kind of my,
That's
I thought that's the discussion we had as well. But.
Yeah. So for Sundays are my quiet days. I like to go to church, come home and relax. But I also work in my yard on Sundays because that's the day, Saturdays are usually events or activities for us, and so Sunday is my day. So if someone wanted to mow their grass and do their weed eating or, whatever, if that's what they do in their yard, that would potentially be something that their neighbors could report them on because it says all day Sunday.
And all day Sunday has always been in there. So if it hasn't been an issue for you or any of your neighbors, it probably won't continue to be. This is typically the complaints that we get on the all day Sunday or during the quiet hours is usually, as Commissioner Eggers said, golf courses, folks that are mowing lawns very consistently, very loud equipment, or you're kind of repeat offenders. You have your person who's remodeling a home all night long, all day on the weekends. But it is very rare. We just needed something in there to be able to define it a little bit better so that we were able to move forward for those complaints because it wasn't in there before. Again, the all-day Sunday has always existed. It's been something that we did not actually change that. We just changed the term quiet hours and defined it to accompany the times that were already in there and the decibel levels that were already in there.
And if I could add to Jude's response, what you'll see throughout the ordinance, which is already there and probably, I'm sure, added in some places too, a lot of these standards are tied to unreasonable noise or noise that offends a reasonable person. So is it unreasonable to mow your lawn on Sunday? Absolutely not. So there is a bit of, reason tied in here. Is it unreasonable to scream and yell at the pool party next door? Maybe it is, So, but keep in mind on Sunday, that is going to be something, but I think that reasonable is going to always play in here.
Okay. I don't live in an unincorporated part, so it wouldn't be necessarily me. I just gave that as an example because that's what I do, when I have the time. But if it hasn't been an issue, but I know I'm one of those people that if I lived in unincorporated, I'd be breaking.
So just don't take all day to mow your yard.
Listen, it's hot outside, so, I'll go up one side and then sit for 30 minutes and then go down the other side and sit for another 30 minutes.
To reinforce what Jewel provided as well, a lot of this is discretionary. And obviously, we have to be able to substantiate it to a judge. So the judge has to feel the same way. And, what kind of reasonable person, there's some kind of standard terms for it. 10 people walking out of a 7-Eleven, your grandmother might be reasonable. Basically, this isn't, we're going to consider every factor that comes in, every piece of evidence that may be provided. Somebody who mowed their lawn for a few minutes by your barbecue probably was not going to meet that criteria, and it would be very difficult to substantiate that in court. But those folks that are doing it repeatedly and established a pattern, and we've got witnesses that are going to come in and testify, they're going to provide that evidence. We now have that ability to move forward with that. The judges have been, the courts really have been asking for some more specific information. They want the ordinance to fully address what we are bringing to them. So previously, we'd bring them a violation that was relatively consistent with the intent of the ordinance or the intent of the law, but they've kind of strayed away from that a little bit and are really asking us to dial in the exact things that are going wrong, and they have to hit the ordinance very specifically. So through that process, we've determined that we really need to kind of tighten up the ordinance and add those definitions. You did mention 10 p.m. quiet hours. There was some previous discussion about that. Welcome to have some more discussion. One of the things that we took into consideration, we have a lot of community business partners who rely on those 11 p.m. hours. So that was something that we didn't really want to get too deep in on. They're typically not too much of an issue. Those complaints are kind of few and far between. More so the residential complaints that are occurring from your transient properties and some of these itinerant issues that are happening during hours before 11 p.m. That are considered, more so to be quiet hours in residential areas. So we went ahead and dialed that in to be a little bit more consistent with some of the other accompanying ordinances in the county.
And my last is, I know we talked about this before, sometimes you have neighbors who don't take it, they don't consider it to be very kind when they are reported. So their neighbors sometimes are hesitant about doing it because of the ongoing or potential for ongoing confrontations. And so before I would say, we'll then call, I guess a commissioner or whomever, and we could report it on your behalf. But with this, and the desire or intent to submit an affidavit, that would need to come from the person who was directly impacted. So would their best alternative then be to call the police and hope that they could get there while the noise is still going on so that they could be the ones to, because you do have some people who have called or emailed us, maybe individually, and they don't want to get into a back and forth with their neighbors because it may not be a good thing, so.
Yep. So that's a kind of a two-part answer to that. The first call based on kind of the type of noise, which is usually going to be the stuff that we get in residential complaints, should usually go to the sheriff's office. We have some other established ways to report that, but the sheriff's office are the ones that have deputies all over the place that can typically respond to these on a moment's notice. Code enforcement doesn't have folks staged everywhere to be able to do that. So, again, the SO can usually get there within a few minutes, sometimes a little longer, depends on their call load. But that's always where the first call should go. A continued complaint or a follow-up call can certainly come to code enforcement, where we can, again, I'll say a little more bite when it comes to your monetary fines to get folks' attention. But that call to the sheriff's office, they're the ones that are going to knock on the door. They're the ones that are going to tell folks to turn it down, and those folks will usually turn it down pretty quick. That's not something that code enforcement does. We do the follow-up, and again, build a little bit bigger of a stronger case against a homeowner, and then take that homeowner either to a magistrate or court to try to get some compliance. The second part to that was the reporting, the anonymous reporting. A couple years back, the state did put a stop to anonymous reporting. So no matter what, we're going to need that complainant to call in. I don't know how the sheriff's office deals with it on anonymous reporting for ordinance violations. They have a couple of different processes depending on the phone lines you call and the things you say. So some of their stuff is restricted from public records, but as far as code enforcement, we have to have that complainant. And the ideology coming behind having the affected party being the one that calls in is we really need to be able to establish whether or not that person could actually be reasonably disturbed by the noise that's happening. And again, other factors we take into consideration too are your ambient noises. So, if we get a noise complaint along US 19 and you've got 6, 7, 8 lanes of roads and frontage roads and semi-trucks driving by and stuff, we set an ambient noise level, and if we can hear that noise beyond that at that person's residence where they're able to, where they're filing the complaint from, that's going to help us actually enforce what's going on there. So not only will we take the noise complaint from the property line of where that noise is coming from, and in some cases it's a residential property line. For example, if you have a bar in a commercial industry or a commercial area, we're going to take that noise reading from the closest residential property line, and we try to do that as it relates to the person who's making that complaint. So it helps us build a stronger case, and then again, we do need their testimony and any evidence they've been able to collect to be successful.
And I get it, you don't want people to, they're just mad at their neighbor, so they start calling in all these complaints and stuff, which really wastes time and it costs money when you're calling people. But then there are some instances where people are genuinely afraid because, threats do happen, unfortunately, when people don't want to be good neighbors. So I appreciate your information, though. Thank you.
Certainly. Thank you.
Yeah, so the 10 o'clock, 11 o'clock deal, the only thing I worry a little bit about moving it back to 10, I understand the consistency, but we don't have a lot of downtowns in the unincorporated area, but we do have downtown Palm Harbor, which has a lot of businesses that continue to rely on restaurant, late night. They have music outside. A lot of the restaurants there are outside, not inside. I know in Dunedin recently, they did this whole change of noise ordinance and 3 o'clock in the morning instead of 1 o'clock, and now you have to take it inside, or do you have to take it inside, that whole thing. So have we been, no, I haven't heard of anything. We usually get all the calls up there, but I haven't heard any complaints. Any complaints that you guys have heard on in and around the downtown Palm Harbor area?
No, in fact, I can't recall any complaints that have come directly from there. I have brought our North County supervisor with us. He can give me a nod. Do we have any complaints in that area? But we do have a couple of commercial complaints along the 19 corridor in one of the busier areas. So we occasionally do get those complaints. Typically, those businesses are pretty quick to respond. They don't, the after 11 issue has really not been a problem for us, specifically in the Palm Harbor and northern region. We did have a couple of bars down in the South County area that were continuing to do that, and one of them actually shut down somewhat as a result of the continued violations. They had a couple of other concerns as well. They will typically respond and take care of that. One of the things that, and I'm not the biggest expert in this area, and I defer to Jewel on this, but a little while back, the state did establish a new law that basically prohibited us from establishing any rules that might hinder a business ability to continue to profit if they were to articulate that a major change might affect those clients that are coming in. I would defer to Jewel on that and her team, but I would kind of consider that before we decided to make those hours any earlier.
And that would be my only concern about messing with that 11 o'clock time frame just on some of those businesses in downtown Palm Harbor. And it's good to know, we haven't gotten any complaints from residents either, so it's good to hear that that's not creating problems. So.
Exactly, and it doesn't create a problem between commercial to commercial or industrial to industrial, where we have different standards, but we've never had thirsty marlin complain about Bogota and so forth on some of those other businesses
It's
over
more
there.
about the surrounding residential that might complain.
And we haven't had any of those.
Okay, thank you. Appreciate
Absolutely.
your presentation.
Thank you. What else?
Hey, do you just remind me again, the quiet hours for short-term rentals 10 to what?
10 to 9.
9. Okay.
Yes, sir.
All right. All right. Thank you very much.
Thank you. Appreciate your time.
All right. All right, moving on to our Land Development Code tree regulation update. Exciting stuff. How's it going, Kevin?
Good morning again, Mr. Chair, Commissioners. Kevin McAndrew, Director of Building and Development Review Services. With me is Stacy Tippins, who is our Development Review Services Environmental Division Manager. And I want to start by formally introducing Stacy to all of you. She's been with us now for a little bit over 6 months. She's joined us from her role in Sarasota County, although she is a lifelong Pinellas County resident. And Stacy's just been a fantastic addition to our team in BDRS. She's an accomplished environmental professional with over 10 years of experience, and she's led really key initiatives in Sarasota, streamlining permitting, innovative policy implementation, and regulatory compliance. As I said, she, within days of joining us, had insightful observations and recommendations that we were immediately able to implement, resulting in improved customer service delivery, as well as realizing some efficiencies. So I'm very excited to have her lead our presentation this morning. Before doing so, I want to sort of set the context to this presentation, starting with the question, why? Why do we regulate trees? Why is canopy preservation important? Why is it important to recognize and preserve native habitat? The benefit of trees and tree canopy are far-reaching and important. I think we often think of the core environmental benefits, and I'm going to hit a couple of those, but I want to emphasize that the significance of trees have also many and numerous economic benefits. I'm going to just start with one, which is reduced energy consumption. When trees are planted in the right place on a property, whether it be residential or commercial, they can have significant energy savings to that building, including cost savings of up to 25% on utility bills. So this is something important that is not often always recognized. Some of the more core benefits of cleaner air, reducing ambient air temperature, which is often referred to heat island effect. Those, I think, speak for themselves, their importance. I want to hit on two others, though, that really check both boxes on the environmental and economic side, and starting with stormwater management. Trees and their canopy, their absorptive qualities, their canopy intercept have a significant role in reducing stormwater runoff. Not only does it benefit the properties themselves, but it also translates to savings in public infrastructure. There's been studies done that in densely populated areas, such as Pinellas County, tree canopy, when it's consistent with good coverage, can reduce stormwater runoff by as much as 7%. That's a significant number that translates to the bottom line on hard infrastructure costs. The last one to kind of round out some examples of the importance here is property values. There's been many studies performed that neighborhoods and districts that have good tree canopy coverage have higher property values, as much as 10 or 20%. So it's important to sort of just kind of set the stage with all of these benefits that aligned with tree canopy and the importance of it. And in the most simple terms, the way I can put where we're trying to take this discussion is that our goal is to have an outcome that improves participation in our code, optimizes canopy retention, and incentivizes getting trees planted in the ground. And Stacy, when she makes her presentation, she's going to infill much of what I'm referring to when I talk about an improved outcome, which is just part of a key driver to where we're going. There's really three core areas that Stacy's going to touch upon within the presentation. The first one is tree mitigation. When you're removing a tree, what's the methodology? What's the formula? Again, our goal is to incentivize compliance and utilization of our code. The second, specifically unrelated to tree mitigation, has to do with the required number of trees on residential lots. And lastly, bringing flexibility to landscape compliance. So with that, I'm going to have Stacy pick it up from here.
Well, good morning, commissioners. Thank you for the opportunity to come talk to you about trees today, and thank you, Kevin, for that very lovely introduction. I'm going to jump right in with a couple of examples that will kind of draw a picture for you all about the challenges that staff and the regulated community are facing with our current code. So in our first example here on the left, we have our average size developed single-family lot where the property owner wants to expand the driveway by adding a parking spur, which will impact 2 existing trees for a total of 40 diameter inches. This is just how we measure trees, diameter at breast height, proposed for removal. Our current code requires mitigation on an inch-for-inch basis for all healthy tree removal. So with that, this proposed work would require 27 2-inch caliper trees to be replanted on this site. Now, this is, as Kevin mentioned, in addition to and exclusive from the minimum landscaping requirements, which for a property this size is 2 shade trees. So we have a total of 29 trees that have to be planted on this site to comply with the current code. Since
Excuse me, real quick.
Sure.
Just make sure I'm clear on this. So you're saying that this driveway was, this little side driveway was added, 2 trees totaling 40 inches?
Correct.
Was removed. And you're saying that to replace that, we need to plant 27 shade trees?
That is correct.
Okay, just want to make sure where we are. That's, I mean, you know, context is important, and you started the context in our conversation. That's why we need to look at this, because to me, that's just like, you know.
So she's jumped into some examples, and what she's going to walk through is why we're proposing some changes. And so this is an example of a typical development and what the current ordinance is, and then she'll show examples of what a revision to that ordinance would look like. So she's going to use some examples to where you can get the context that you're looking for and what both they are dealing with now, but also the development community as they face these situations.
So if people are listening, I just want to apply just one exclamation point to her comment.
Yeah.
Because, again, I think if you're a Floridian, you have a little bit of environmental in all of us, right? And so we want to make sure that we, to your point about the context of having trees is really important. But sometimes the tail ends up wagging the dog. And I just wanted to make sure that, to the point that you're bringing up, that's a lot. So I appreciate the effort that's going on, but I also wanted to put that little exclamation. Thank you for letting me do that.
No, I appreciate that emphasis, and to carry on with that, as you can see, our plantable area here shown in yellow for this site can really only sustain about 2 trees given the space that they need to mature to their full size. So that lets them meet the lot minimum and requires them to then pay in lieu for the mitigation for the rest of the trees, which based off of our current code would equal a little over $10,000. Obviously, this is calculated using the average market price of a 2-inch caliper replacement tree that would be required, and you know, these numbers can be prohibitively expensive for the average private property owner. In the second example we have here, we have a larger, heavily wooded lot where they're proposing a single tree to be removed to facilitate a play area. The current code, again, would require entrance replacement for this tree, resulting in a 24 replant tree requirement. And since, as you can see here, there's really no suitable replanting area, this again would have to be paid into the tree bank in lieu of planting in an amount equal to about $9,000. This, again, is in addition to the 44 tree landscape requirement, which for this site we can safely assume is already being met.
Is that the new, is this represent the new tree bank fund that we implemented already? Or is that something that we're?
This is all existing. This is our current lay of the land.
And we made a change on the tree bank cap, where we talked about that. Was that just something you're proposing, or is that something that's already in place? Where you can pay into a tree bank, or was that sidewalk? I get confused between the two.
That's sidewalk.
Okay,
Sidewalk,
thank you.
yeah.
That's another one for another day, sorry. I want to make sure I get
It's like,
that.
yeah, I don't do sidewalks.
And she's going to walk through, how this would propose, but really what you're seeing here is 2 examples where the property owner probably just isn't going to do it, because, the cost into the tree bank would be probably greater than what the little pad would cost, or about the same. And so, in essence, it doesn't like make sense, right? And I think that's the examples of we want to, they started with, we want to preserve the canopy, but we've got to look at something that, makes sense based upon the site conditions, a little bit different, and not prohibit people from being able to improve their existing property and stuff, so.
So Stacy, the example there on the wooded lot area, so to remove 1 tree would require them to plant 68 trees or pay a fee?
No, so the required replant trees is calculated by dividing the DBH by 1.5, and that's the, 24 shade trees is the replant requirement. Landscape requirement is separate, and they're already meeting it here, so they're good, hence the little
Removing
check
1
mark.
tree would require
24.
24.
On a lot that is completely wooded.
Treated.
That's all.
It's already completely wooded. But again, it's taking a canopy out, but
Yeah.
you can see why the situation, from a homeowner's perspective, you go, really? I'm surrounded by trees.
Well, that's why people are just going to take a tree down and not tell you. Right.
That never happens. All right, so I hope that these examples have painted a picture for you of the challenges that we are trying to address here with these proposed changes. You may be aware of some legislative changes that occurred in 2019 that have provided property owners with a new option for exempt tree removal for hazardous trees that they did not have before. And unfortunately, my staff and I are seeing that this exemption is being frequently used, sometimes misused, and it's not uncommon for us to provide mitigation information based on our current code only to get a, never mind, from that member of the public that's reaching out to us. The second challenge is obviously the tree requirements, the landscape requirements for a residential lodge, which is compounding the issue because it's adding more required trees to limited space. We have a few options for how to proceed with this. We could focus on just revising the mitigation calculations and the minimum landscape requirements. We could focus on just changing the payment in lieu costs to reduce the overall cost of mitigation, or we can move forward with this comprehensive revision that we have before you today. The outcomes that we're aiming for here with these revisions is a focus on, like Kevin said, preserving and restoring urban canopy in unincorporated Pinellas County while encouraging the public to participate in the regulatory process instead of using exemptions, sometimes misusing exemptions to avoid these additional costs associated with mitigation. So our changes span two different chapters of the Land Development Code. Chapter 166 contains a lot of our more general procedural requirements, while Chapter 138 goes into landscape requirements and the actual tree removal permitting criteria. There are 4 key changes that we're looking to bake in these sections that I'll dive into a little bit deeper, and then some other smaller changes that are really supportive of these overall goals. So our first.
One question, I'm sorry.
Sure.
So going back to that previous slide, tree rating system and, you know, again, natural trees to Florida, palm trees don't count, right? I mean, to me, they're a natural tree to Florida, but if you're asking for more trees, they don't count towards the, currently I'm saying, towards the tree canopy that we can choose as a resident. Is that?
They count at a lower ratio. You can plant them in clusters to count as one shade tree.
Okay.
And only certain species.
Okay, thank you.
Sure. So our first key change here is this rating system, and we're simplifying it pretty substantially. We're going from 7 categories in the existing to 4 proposed categories with these changes. And the hope is that this is going to be much easier for the regulated community to understand and to apply when they're submitting permits to us, and also for our staff to apply when we're reviewing those permits. These changes will promote the voluntary removal of undesirable trees, invasive species, and it'll also be requiring appropriate compensation for larger, healthier trees that we would otherwise want to retain, but need to be removed for development purposes. Importantly, these changes prioritize the preservation of the largest, highest graded trees that provide the most benefit to the community. So our second key change here is recalibrating the mitigation methodology, which is the little math equation I mentioned earlier. I know this slide is a lot to look at, so I'll kind of try to break it down for you. Our current code requires inch-for-inch mitigation for any healthy tree, essentially. This proposed system meters that required replacement based on the grade of the tree, which you can see across the top, and the size of the tree down the side, so that we're requiring less compensation for lower grade, smaller trees, and more compensation for higher grade, larger trees. This slide also goes through the various options that property owners have to comply with these mitigation requirements. So they can replant all the trees on the same site. They can make a payment into the tree bank in lieu of replanting, or they can choose to do a combination of these 2 options, which is the most common outcome selected by most property owners. So the payment in lieu rates are set by the Board of County Commissioners. And here, based on our review of some comparable jurisdictions' codes, we have proposed a $500 per unplanted tree rate, with a lower rate for existing residential properties that are more constrained as far as replanting requirements. This system is certainly more straightforward than the current approach where we're doing some math. And I think it's going to be a lot easier for the community and for staff to apply.
Excuse me. On that table there, just if you removed a 4-inch or up to 14-inch tree, the number of replants required of a, are you saying if the tree that was removed was in excellent condition, 3 have to be, okay. All right, I thought you were, when I first read it, it was the condition of the trees that you're planting. Excellent, good. It's not. It's the ones you're removing. Okay.
Numbers, yep.
Now the table makes the sense that you're, yeah, okay. Thank you. All right, that's all I had. Thanks.
Okay, so we're going to take those 2 changes.
So we're looking at just going to a flat fee then for,
Correct. And the flat fee is per unplanted tree, as opposed to an inch-for-inch situation. It's not going to be based on market values. It's based on these numbers, which are consistent with our neighboring jurisdictions.
so if I took out a tree that's greater than 34 inches, and I'm not going to replant, and it was excellent condition, so it would be 12 times 500.
If you are a commercial site, correct. All right, so combining these 2 changes, we have this table that compares existing versus proposed mitigation. The effect is that there will be overall lowering of the replant requirements. We have several examples on this table of the different sizes and different grades of trees that may be proposed to be removed. And if we look at the example of the 31-inch grade 2 tree on the 3rd line down, we can see that the current code would require 21 replacement trees, and the proposed code would require 6. And this is an average size tree and average health. The current payment amount for this would be just under $8,000, and with our proposed payment in lieu amounts, that would be $1,800 for a private property and $3,000 for a commercial property. So while these numbers may look drastic, I'll remind you that most, if not all, property owners are not replanting their entire replant requirements. They're doing a combination of replanting and payment in lieu. So again, in a lot of cases, we're seeing folks withdraw their applications when they hear about the mitigation requirements, and the hope here is that this is setting them up for success so that they can comply with the code and participate in the permitting process. And keeping with the options theme, we do have options for property owners to receive credits for removal of undesirable species. They can plant native ground cover and understory vegetation to create these native vegetative communities, which are defined in the code, and that will provide them some credit. And as with the existing code, this is not changing. The highest grade trees have the highest criteria, and so those can only be removed when they prevent access to or development of an existing lot. All right, so our 3rd key change here is reworking the minimum required trees per lot in a way that ensures that the planted trees have sufficient space to grow to their full size and maturity without impacting any surrounding structures requiring their removal in the future. These changes are pretty modest, but you'll notice with the existing code, there really was no upper limit as the size of the lots increased. And so we've added a cap on the upper end to just prevent the runaway landscape requirements as we get into those larger lots.
Question, I'm sorry. Go back one slide if you would, and just looking at the double credit for replacement of native vegetative communities. So in the list of undesirable trees, which whatever those might be, are removed, what do they have to be replaced with? These tree requirements you're talking about, these mitigation things, those are all like the right kinds of trees.
Desirable trees.
So if you remove undesirable trees,
They require no replacement. We want them gone.
We want them gone. Okay, so you're not, all right. Okay. But you get no credit for them either for a
Correct.
minimum number of trees on your lot.
Correct.
That's the part that just bugs me. That you get no credit for, you buy this lot and it's treed everywhere. And when you do the inventory of the trees, and of course, if you're a home buyer, I mean, you're not looking into like, well, let's do an inventory of trees because none of these are valid. If I build a home, I'm still going to have to put up a certain number of trees.
Sure.
As opposed to, well, I don't have to deal with trees. I've got so many trees on this property. None of them count.
Correct. And under the current code, there is no option to receive credit for removing those. It's a requirement for certain permits. So in this case, we're providing some credit for folks who want to take out those trees and replant desirable trees. They're getting credit where they otherwise wouldn't.
But it's not credit towards tree replacement, it's just,
Towards mitigation requirements, not landscape requirements.
it is mitigation towards the tree?
Correct. So theoretically, a property owner could mitigate by removing undesirable trees and planting shrubs and understory to create native vegetative communities if they're unable to plant shade trees.
Thank you.
All right, so going back to our examples now, which have been modified based on these proposed changes. Our 5,500 square foot lot on the left here, the replant requirement has come down to 6 trees from our original 27 trees, and the tree bank contribution has come down to 1,800 from the 10,000. The lot requirement here still just happens to be 2 trees, and the planting area, since it can sustain only those 2 trees, we will get those 2 trees planted. However, with these revisions, the owner may choose to also plant native vegetative community to count towards their mitigation requirement, which would reduce the number of required replants and reduce the payment in lieu amount if they choose to do that. So we will end up with a better environmental outcome because we're getting our trees plus our native vegetative community under this new approach.
So again, sorry, just trying to understand the details a little bit without, I guess one of my questions was, have we had any contracting group, that group that sometimes looks at our ordinances and look at this yet? People that actually work with this every day?
We did. In fact, Stacy made almost this identical presentation to DCAG at our last meeting.
And how was it received?
It was received very favorably.
I mean, yeah, because if you don't work with this, it's hard to understand all of the moving pieces. So I just want to give back to this example that would have required removing 2 trees. They're 40 inches of diameter. And it would have required in the old code that I exclamationed in the beginning, 27.
Correct.
Now we're requiring 6 trees. And what type of trees, what size of trees would you do there? I mean,
So we have an approved species list. I'll actually get
Right.
into that later.
size, I was thinking more about size.
Size, currently, we have 2-inch caliper Florida grade number 1, which is pretty standard across all of the communities.
So 6 like that,
Correct.
okay. And then also additional landscaping requirement.
Correct. So a total of 8 trees in this example.
Or landscaping.
I just want to clarify that under the landscaping requirement, this is an existing home. Those 2 trees should already be there. This is not, we're not saying at this time, the county has had these requirements for minimum number of trees on lots for decades. So what often does happen, though, is that when there's an inspection performed to look at the quality and the size of the trees that are proposed to be removed, there are cases where the inspector will take note that this lot was supposed to have 2 trees on it. If they have 1, they would need to add 1 additional tree to meet that minimum landscape requirement. The 2 are there.
Okay.
It doesn't apply.
Okay. Gotcha. Thank you.
All right, so our larger wooded lot example here on the right has also had a reduction in the required replant trees from 24 to 8 trees. The reduction in the associated tree bank fund, if they go that route, from 9,000 to 2,400. And again, they're still meeting their landscaping requirements, so that does not compound the required replant trees. Now, in this case, the owners could choose to replant native vegetative community for all of their mitigation. And so we're getting the benefit of restoring these native vegetative communities where before we would have had no trees planted.
The point I want to also emphasize on the 2-acre lot is that if this lot, which we have encountered this, had no trees on it, at the time of a new home was being built, under our current code, they would have been required to plant 44 trees. Under the proposed code, if it was a lot that had no trees on it, they'd be required to plant 15.
It was interesting because I think we've talked about, like up in North County on some of those large lots, one lot will have 50 trees on it or 100 trees on it, and the next lot is empty. You know, so if you were going to build on there, the requirements are just different. That's what you're saying right here. You wouldn't have a landscaping requirement in the one example.
Correct.
In the other one, you would have a landscaping requirement.
Yes.
Okay.
But we're recalibrating that, again, where it's scalable now to, there's a cap, as opposed to previously in our current code today, there's not a cap. That number would just keep on going up. If you had a 5-acre lot, the number would be that much more.
And before I forget, where do these tree bank dollars get used? How do they get used? And what are our funds up to in that?
So the funds that are collected through DRS are distributed to parks. I understand that there's also a certain percentage that may go to Public Works.
Works.
You know, the annual contribution for payment in lieu is something that fluctuates significantly. We had an example of a development just a year and a half ago that had $1 million, $1.1 million payment in lieu. Large development, multifamily development. That's not the norm.
Right.
So, you know, that's an anomaly. There's many years where we don't have that, especially in a developed county like Pinellas, we don't have that typical scenario. We're generally infill, so we're dealing with, you know,
Small amount.
amounts that are significantly less than that on an annual basis.
So do we have a tree fund now?
Yes, we do, Commissioner, and we use these to plant trees. And so in essence, rather than doing it on your property because of the situation, it's reforestation somewhere else. And so it's used for the same purpose. And that's the reason for the fund, and that's what it's used for. And currently Parks uses it.
So
and
does it get depleted every year and then build back up and then?
No, it doesn't, and that's another discussion because we have both funds over in Public Works and we have over in Parks. So there's some internal discussions because of that large amount that Kevin just talked about. It's kind of made that we didn't have that before the $1 million program come in, and so that's the discussion that's kind of changed that. But we'll bring back ideas. We have internal discussions. We haven't resolved.
So when you bring
yet.
back ideas, then you can tell me what the fund is at?
Well, I would have to defer to staff. I really don't remember.
Okay, no, I'd like to know, like, do we have $1,000? Do we have 10 million in there, or, I mean,
I'm seeing staff kind of look at each other like,
Okay,
who's
well,
going to answer this question? So
I can clarify what the fund is in Parks, you know, approximately it's $3.8 million.
in the parks? Yeah. The parks piece of
Yes.
that? And then there's the Public Works piece also that?
Yes, which I don't know that amount.
Okay.
And again, this could be a misleading,
No, I understand.
misleading sort of conversation because in addition to that 1.1 million, we also had one for $650,000. So we just had, like I said, a rare occasion where we had two developers, two large properties. They clear-cut these properties. There was zero intention of tree preservation. And in this case, they just chose to build the cost of tree mitigation into their pro forma, into their development, and made the payment to the county.
To put a point on this, and what I think is a very important thing to understand is either of these properties being residential could have opted to use an exemption to remove trees without going through the permitting process and requiring no mitigation. And in this scenario, the hope is that these property owners will be more likely to come to us, go through the proper channels, and participate in the permitting process. Okay, our last key change is addressing commercial landscaping requirements to add a little bit of flexibility and some additional options for landscaping that was required under previously approved site plans where that site has existing landscaping that meets the purpose of the code, where site conditions can't support additional plantings, or where the scope of the redevelopment, such as a change of use, is very limited and doesn't warrant requiring additional landscaping. And the other minor changes that I had mentioned, we already discussed a little bit. We will be updating the approved species list and the undesirable species lists. For the approved species list, our focus is really going to be on the right tree, right place approach, which will give property owners options to plant trees that they want, that work with their property, and that will not, cause issues and be removed later on. For the undesirable species list, we're really updating it to incorporate some new horticultural information, where we've assessed some additional species that have been determined to be problematic in the area, and we just want to ensure that those species aren't being used for landscaping in unincorporated Pinellas County. So to sum it all up, these changes are aimed at encouraging the regulated community to participate in the process by adopting a balanced approach to the mitigation and landscaping requirements for residential and for commercial properties that sets property owners and staff up for success. As with all land development code changes, this will go to DRC, LPA. It'll come back before you all 2 times before final adoption. If we have smooth sailing, we predict that this could be adopted by the end of the year for an effective date of January 2026. And I will take any additional questions that you all have.
Okay, Commissioner Nowicki and then.
Thank you, Chair. I'm not sure I really have a question, but, I'm trying to really understand the intent, kind of behind simplifying the ordinance and encouraging compliance, which I think is a reasonable goal. But I'm concerned that, in trying to make things easier, we're kind of giving up too much. In the case studies, we're showing mitigation costs dropping from over $10,000 to just $1,800, and, the required planting shrinking, pretty significantly, in both dollars and canopy replacement. So we just think that trees aren't worth as much as we thought they were, or that we don't need the money anymore to maintain our, canopy and native vegetation goals. I want to support homeowners and property owners, but, I also want to make sure we're not unintentionally sending the message that trees don't matter, or that restoration is optional. So I think it's about finding the right balance, and, if this is kind of what we're proposing, I still think a little bit more work needs to be done to strike that balance.
Sure. Fair input.
Well, Stacy, thank you. I appreciate all your hard work you put into this, because there is a problem. Matter of fact, the first example on the left with the house and the driveway, I know I have an employee that has that exact problem. She doesn't have room to put 21 trees on her property. She can't take the tree down because she's got, but it's destroying her driveway, so thank you for working on that, but my problem, and just philosophically, just to tell the board how I feel about this, is that I consider this whole section of our land development code to be an example of excessive overreaching governmental control. The very idea that I need a permit to cut down a tree that I own on my property, that I have to pay for a permit, that I'm subject to mitigation, or I have to pay a fine. The whole concept to me is an affront to property rights. I find it repugnant, and quite honestly, I think it's un-American. The whole idea is a tree. Kevin, there's a lot of reasons to want to keep trees. I want to keep trees, but a lot of people are very allergic to oak trees, okay? They don't want them in their yard. They got to get rid of them. They're tearing up driveways. I mean, there's just a lot of reasons to not want a tree in your yard. Maybe you ought to put a swing set up for your kids on the weekend. Well, I don't think I should have to go get a permit to cut down a tree to make room for a swing set. Now, like I said, there's a lot of reasons for trees, but I think we should let the citizens of Pinellas County decide whether or not they need a tree in their front yard, or which type of tree they're going to have. But like I said, there is a problem. And so my thinking is, to solve the problem and give people that live here more freedoms, maybe we should just eliminate the requirement for trees under a certain size. Like, hey, trees in residential subdivisions under 31 inches, you don't need a permit. Just don't even come see us. Why do we have to do all this overthinking a problem? Just eliminate the problem by eliminating the requirement. I just don't see the need for it. Some people want more trees. Some people want to take a tree out. Let them take the tree out. They own it. They're paying the property taxes on the property. I just think it's too much government. So that would be my simple solution to some of your problems there. Get rid of the requirement altogether.
There's two vastly different opinions. But commissioners, as you can see, and you're probably going to hear, about some from folks on this. But what you also have right now is a state law that says that if a arborist, determines a tree to be unhealthy, they can take it out. And so you're trying to get compliance. And you want people to go through the process. And to your point, Commissioner Nowicki, that's what you're actually dealing with in the first example. They're either not going to do the development, or I'm going to get somebody to certify the tree. And if I can get that, then I don't have to worry about you, and I don't have to worry about a permit, And so you're trying to find that right balance. So they've tried to come up with something that strikes that balance, tries to get compliance, and be reasonable to what a homeowner would view as currently an unreasonable situation, that if I'm going to put a little pad to where my kid can park in the front yard, it's going to cost me more for the mitigation for the two trees than it does to put in the pad. And I think an average homeowner would probably find that unreasonable. And so they've tried to strike that right balance. There may be varying views on that, and as the ordinance come forward, you can debate that.
I want to also just reinforce what Barry's saying. That is the term balance, and I will tell you that it is on a daily basis. Never underestimate the creativity for individuals to circumvent ordinances. Because of this code as it exists today, we see it on a daily basis, where they just walk away and don't play ball with our ordinance. I want to also emphasize, too, that we're not blazing a trail with what we're bringing before you. Stacy referenced a couple of times that we're aligned with comparable ordinances of other municipalities. I want to share with you that my last major assignment with the city of Sarasota was updating their tree ordinance. And there's a number of key pieces within this ordinance that are aligned with that. And I can tell you that they had a tree advisory committee that was in place for 3 years. Esteemed arborists, landscape architects. I'm a registered landscape architect. I live in this world for decades. This is part of what I dealt with for decades representing developers. So I know the material. I've worked with dozens and dozens of tree ordinances. And we're trying to incentivize and reward putting trees back in the ground. As the code is today, like I said, we just see every end around possible. And when the city, when their tree advisory committee had brought an inch per inch proposal, it was dismissed. When again, is it possible to have an inch per inch? It is, but it is incredibly complex to manage. And we don't see the reason why we have to have an overly complex ordinance that's not going to yield any better outcome. And so, again, we've been from the outset said we need to align ourselves with what other municipalities are doing and strike that balance where I can tell you, I don't have the number with me, but under this proposed ordinance on those developments that I referenced that had a 1.1 million, we're not giving away the shop with this. They would be subject to the $500, not the $300 per tree. And we'd still be talking about substantial in the hundreds of thousands of dollars if we do have developments like that come forward that will be contributed to our tree bank.
Commissioner Eggers.
Okay, well, and I was going to ask, in those two examples that are, behind us, what would those fees have been under the new ordinance, the new proposed versus what we had in place that gave us 1.7 or 1.8 million dollars? So just trying to get a feel for that impact. You don't need to do that now, but so I've always said to folks, like, if you want to plant a tree, it's yours until it's in the ground. Then it belongs to local government, essentially, because then if you want to take it out, you have to justify the reasons. Damage to your home is a reason. If that happens, they're allowed to take it out. Do they have to replace it? If there's a tree whose branches are causing damage to your home and you're allowed to take the tree down, do they have to replace that tree at all?
It depends on the health of the tree, and typically when trees get to the point where they're causing damage to structures, they're dropping branches, for instance, they're on their way out. They're a lower grade tree, and they would fall into that category that requires either low compensation or no compensation.
I've seen some pretty healthy trees, and those branches just crawl, and then they get up underneath and start to do damage. Same question for if you want to add a pool to your home, and there's two trees, healthy trees, and they're there, but to do that, to build on you have to replace those trees.
Correct. That would be exactly similar to the expanded driveway example, other than it just being a pool
versus
a pool in the backyard.
Okay. Okay, and then the last thing is, over the last years of dealing with this, and many residents and many developers or contractors who've been outraged, and I've always thought that, Kevin, the respect I have for you and the department. Is there enough flexibility in this new ordinance that we're going to be bringing forward that staff has some wiggle room on some of this stuff? Because anytime you put rules in place that are so rigid that we may not have thought of something, or we may not, is there any flexibility that's built in here? Are you comfortable with the amount of flexibility that you as the director and your people are going to have to live by?
Yes, I am comfortable with that, and it's something that we focused on from the outset to incentivize, again, the options that Stacy covered with native ground covers and shrubbery that will be credit towards in lieu of planting the required trees for mitigation. So we've been sensitive to building in that degree of flexibility.
Okay, and again, I'm not. I'm not the expert on what that looks like, but I do know with our parks, our conservation area, all the 24 cities and their parks and their conservation area, that canopy is pretty healthy and looks good. Again, that's subjective, and I don't know what that really compares to others, but I think we've done a really good job in this county of just maintaining what we have and then trying to alter as we develop is the key. How do we do that? And I think the reasonableness, the balance that you're finding in on these proposals, I think is healthy. I'm glad to hear that DCAG has looked at it and that they're happy with the results as well. So thank you for the presentation today.
Well, thank you very much, Kevin and Stacy, for the presentation. I think we had a good discussion. You know, my opinion is that we're lowering costs for businesses, developers, and homeowners, and reducing regulation, encouraging compliance. I think all that's good. But fundamentally, I agree with Commissioner Scheer. You buy a piece of property, there's a tree on it, it's your tree. Shouldn't have to ask for permission to do that. I mean, I understand the desire to keep tree canopy and to have a balance there, and certainly Duke Energy doesn't fall under all of this stuff because they do whatever they want to do. Yeah, right. So at the end of the day, I don't really know where I land on it because, I mean, I like the fact that we're lowering fees and we're reducing. That's all good stuff because what we had on the books was crazy. But in the final analysis, I kind of agree with you. I mean, I had our last house, we were surrounded by oak trees, and I had one that was tearing up the driveway, and we ended up not doing anything. We ended up selling the house because I didn't want to deal with it. I didn't want to go through the process that I was going to have to go through to figure that out. So,
As Commissioner Eggers, you know, if you plant a tree, you know, you may not plant a tree because you know that you may have to get a permit to take it out someday.
well, I actually have in that situation in my office now. I want to plant a tree, but I'm like, do I really want to plant a tree? We actually got to, you know, when we have the tree giveaway every year, right? Public Works gives trees away. And I got one. I was going to plant it, and I went, I really shouldn't have to think this hard about planting a tree. So, anyways.
Well, should make for good discussions when the ordinance come forward.
Thank you all.
Thank you very much. All right, now we'll move on to Nebraska Avenue roadway improvements.
Okay, and Kelly and Tom are on their way up. So, Commissioners, you approved this approximately a year ago, and it's through its final design. But you know, there were a lot of changes made, and we did one-on-ones with commissioners at that time, walking through the changes that were made. It never came back in a formal presentation. I think there were some questions, commissioners. We want to show you the outcome of the final design and the changes made as a result of the citizen input at that time. So that's what the presentation is going to be this morning.
Morning, Kelly.
Good morning. How are you? Kelly Hammer-Levy, Public Works Director, and I have with me, of course, Tom Washburn, our Transportation Division Director. So we're just going to lay the framework here a little bit with the project limits and the existing conditions that are there today and where this project actually came from and how long we've been working on it. The goals that were set out for the project, and then we had 2 public engagements that we learned a lot from, and then, you know, our recommended next steps in the process. So the project limits run from Westlake Boulevard to the east and Alt 19 to the west, including the downtown Palm Harbor area. Right now, the area has a kind of an undefined drainage system, a lot of sheet flowing, which is one of our core issues. 2 11-foot lanes and our shoulders are unpaved. We do have sidewalk on the south side, but it's intermittent. And downtown does include bike lanes. We have 3 signalized intersections, and the speed limit through this corridor is slow. It's 30 miles an hour. So this is where we began, is a lot of complaints about flooding. The area, like I mentioned, does not really have a defined drainage system. There are some intermittent swales, but this is very common after a significant rain event, is that the water pools and finds its lowest point. Our sidewalks are not contiguous, and obviously this is a very heavy pedestrian area. There's schools in the area, there's the YMCA, and so it's not as safe as it can be, and we can make it better. When we look at our traffic in this area, from 15 through 19, there were 75 crashes in this area. From 2021 to 2023, we had 44, of which more than half were at the unsignalized intersections. Our recent data kind of shows that at least 15% of the cars have been traveling more than 6 miles an hour over the speed limit in this area. So the request for, mitigation to try to lower people's speed, has been heard from the community, and it was just reinforced with data that was collected. So this project is in the Advantage Pinellas Active Transportation Plan, and it was also identified in the Palm Harbor Master Plan. And you'll see some of the design elements in this project that actually came right out of that master plan. It's been a very key document into what went into this project. Residents said, slow people down. We have a lot of bikes, we have a lot of kids, we have a lot of people walking, and the drainage is a problem. We've heard all of that. We did a project development study actually in 2021, and then started the engagement with residents and businesses along the corridor in 2022, with the preliminary design layout being completed in November of 22. The first public meeting was in February 23. We took all that information, redesigned a lot of the components, and came back with changes in December of 23. And then, as Barry mentioned, this year we updated some of you. So those project goals, again, as mentioned, is roadway safety and traffic calming. We do have a goal to complete and widen out some of the sidewalk on the north side, and repair and replace portions of the sidewalk on the south side, but the south side sidewalk largely remains in place. To add a formal drainage system to address the issues that have been ongoing out there for a really long time. And then, consistent with the downtown Palm Harbor master plan, is adding parking and a wider sidewalk component there in the downtown area. So during public meeting number 1, that was in February 23. After that, we had a lot of meetings with small groups of residents along the corridor, and also fielded a lot of just one-on-one phone calls and emails back and forth with residents getting their feedback. But we heard loud and clear that the first series of designs that we put out there had far too many trees being removed. They wanted to save the canopy. It's very important. They did not like the concept of a wide trail. They were very in favor of sidewalks on both sides of the road, however. So they did want that component, but not the trail. They still were not bought in completely on the roundabout. And again, they were all supportive of the drainage improvements and whatever we could do to calm the traffic down and to reduce speeding along the corridor. So we took that, and we came back in December with a new design. We still had approximately 3 trees that needed to be removed along the corridor. Most of them are interfering with power lines and have, to the point about being trimmed pretty heavily along those corridors, so they're not in the best shape. We did find some innovative technologies to meander the sidewalk and create what's called a rock burrito around the root system to protect existing trees, and then we'll mitigate the 9 that would have to be removed. So this was a significant reduction from the first design. The drainage, again, is a system combined of both above and below ground storage of pipe, swale over pipe, and then some swale systems to collect that water and move it out of the area versus the kind of the sheet flowing that we have going on now. So it's a formally designed drainage system with curb and gutter. So looking at the east section of the corridor, there's no anticipated tree impacts in this area at all. We're looking at just improvements to adding a 6 to 8 foot sidewalk on the north side, not the trail system. It meanders around all the trees and the landscaping to avoid those impacts, improvements to the crossings. But in this area, not significant changes, mostly to the drainage. As we look, this is the cross-section of that. So again, the 6 to 8 foot sidewalk on the north side. And again, most of the sidewalk remains on the south side. We have repairs and ADA upgrades that'll be required. So this will allow for kids on bikes to stay on the wider sidewalk instead of riding in the streets, as you've seen in some of the pictures. As we look into the downtown, you see these decorative improvements at the intersections. Again, this is right out of the downtown Palm Harbor Master Plan. As you move to the west, you'll see that we've formalized parking on the north side of the street. That, again, came right out of the master plan, and there is a 8-foot sidewalk on both the north and south sides as you come into the downtown area to accommodate the additional traffic. And this is that typical section. You have the roadway, the angled on-street parking, and this 8-foot sidewalk on both the north and the south side within the downtown district. And with that, I'm going to hand over to Tom. He's going to walk through 16th in Nebraska.
Thanks, Kelly, and good morning, everybody. 16th in Nebraska, I get the fun part of the intersection. This is where we're proposing the roundabout. So this intersection has received a lot of attention, and rightly so. If you're familiar with the area, north of the intersection, you've got access to Palm Harbor High School. You also have access to the YMCA and to the Palm Harbor Recreation Center. So it's a busy intersection. And particularly at different times of the year, again, since it provides access to the high school, during the school year, particularly during the morning and afternoon arrival and dismissal periods, you'll see in the pictures there's quite a bit of student activity, pedestrians and bicyclists that are crossing at the intersection. What this doesn't show is after that first public engagement, if you were to go out there today, there is an RFB crossing across that east leg of the intersection where they're crossing now. So that was an improvement that we made after that first in public meeting. But there is a lot of activity, particularly during those time periods, so it's not all times during the day. But the other thing about this intersection is it doesn't provide any left turn lanes, so any traffic on Nebraska that's looking to turn left is backing up traffic. And again, during those concentrated time periods, this is when it becomes a problem. We did look at several alternatives before we landed on the roundabout. So the existing traffic control is two-way stop control. 16th Street is stopped. Nebraska currently does not have stop signs. When you look back at the goals for the project, if we were to keep it like it is, it really doesn't address any of the safety goals for the project. Again, during those time periods, we're still creating safety issues and concerns. So the next step was to look at always stop control, stopping both Nebraska Avenue and 16th Street. The concern there is Nebraska Avenue carries significantly more traffic than 16th Street. Nebraska Avenue carries about 12,000 vehicles a day. 16th Street carries about 700 vehicles a day. So your always stop control intersections are most effective where you've got a balance of traffic that's entering the intersection. So again, it doesn't address those concerns. The concern with an always stop control is that backup on Nebraska would be very significant during those time periods.
What was the Nebraska number again? I'm sorry.
The daily traffic is about 12,000 vehicles per day.
Versus 700 for 16th. Thanks.
So the next consideration was to signalize the intersection, and we did look at that. Again, based on the volumes, it really doesn't rise to the level of meeting the requirements. Your signalized intersections are most effective where you have a lot of traffic entering from all directions, continuous throughout the day. So when you're looking at this location, if you think of the intersection of Nebraska Avenue and County Road 1 as an example, County Road 1 carries about 13,000 vehicles a day, so they're balanced and they're very heavy and it's consistent throughout the day. So, this intersection really isn't close to meeting those volume thresholds. It won't provide the safety benefits, and it's a very expensive alternative. Traffic signals cost about $750,000 to install and design, and once they're in, they tend to stay in. So if it's not the appropriate traffic control, we're sort of stuck with it moving into the future. So then we looked at a roundabout, and a roundabout really does address the safety concerns that we heard, slowing the traffic down on Nebraska Avenue. Roundabouts are very effective at doing that. It does reduce the crash severity of all intersection types because traffic is moving much slower through the intersection. You'll see that we address the pedestrians on all legs of the intersection with our proposed design. There is an impact to the properties on each of the corners, and I'll talk about what we've done to meet with them and what we've done to modify the design through that coordination. And then with roundabouts, there is a learning curve. So, but that is the recommendation. So this is what we proposed at the first meeting with the residents. Standard roundabout, circular in nature. And the comments that we received led to the modified design. And so when we met with the residents, we met with each of the property owners and residents. Their concerns were primarily with access to their property. You'll see that we've got splitter islands on Nebraska and on 16th Street. So those properties right at the intersection are most affected. So we did meet with each of them. We've addressed the concerns by adding access points both on Nebraska and on 16th Street. And then we modified the location and the layout slightly so that as traffic is coming through the roundabout and exiting, they're not pointed at any of the houses. And that was one of the concerns primarily that was brought to us by the property owner in the southeast corner. But we do continue with the coordination. We haven't finalized the design, so we are still working through, what we're hearing from them. So the next few slides are just what the roundabout will look like when it's constructed. You'll see this is looking west on Nebraska Avenue, so you can see the splitter islands. It's got the decorative medians, so it'll blend nicely with what we're proposing in the downtown Palm Harbor area. You can see the pedestrian crossings on each leg of the intersection. They'll all have RRFBs to aid in the crossings. The median area will provide a refuge for those pedestrians if necessary for traffic in opposing directions. But you can see from here that it really does blend in nicely with the area. It's not out of scale. It's not out of character, for an intersection of this type in this location. Just another similar photo. This is looking south, so this would be looking from when you're coming from the YMCA. This is what you'd see as you're approaching the intersection. So very standard treatment as if you're used to driving through roundabouts. And then this is just an aerial showing what it looks like. And then just in general, roundabouts have a proven history. We do get a lot of resistance when we first propose them. We're aware of that. But once they're constructed and operational, the responses are generally positive. There is a roundabout in this area that was just constructed at Alt 19, Florida, that was constructed by the Florida Department of Transportation. But there was a lot of resistance to that prior to construction. But we continue, and the DOT continues to get positive feedback now that it's been operational and traffic has had a chance to settle down. Again, they check the boxes for the goals for this project, and that they reduce the speed of traffic entering, so it does provide a traffic calming mechanism. It does reduce the crashes, and the crashes that do occur tend to be much less severe. Around the county, we do have several roundabouts, so it's not completely unknown when you're driving around the county that you won't encounter a roundabout. They're very intuitive as you're coming up to them. And then there's additional ones that are in construction just to the south in Dundee, and FDOT also has 2 roundabouts along State Road 580 that they're in the process of constructing. And then, so our recommended next steps, we're completing the design. We intend to complete the design by spring of next year. Still finalizing work on the drainage design. There's still quite a bit of work to do there. If we hold to this schedule, the intent is to advertise for construction next summer, begin construction late 2026, and then construction duration for this type of project is about 2 years, so we'd be looking at construction late 2028. With that, thank you for your time and happy to answer any questions.
Questions? Commissioner Nowicki.
Thank you, Chair. And colleagues, I'd like to, remind you that, I kind of brought this up in December, that this is, an issue for me. I don't support this project. And if you still go out to Nebraska Avenue today, there's still signs all up and down the road, all in Nebraska Avenue, that say they do not want this project. And so there's just a few kind of misconceptions, I think, in the presentation that I'd like to, talk over with you, Chair. Just, 7 points that I have. They talk about, tree impact minimization. They claim that new innovative drainage solution will save trees, and say only 9 trees need to be removed. That's a fallacy, minimization downplaying by saying, the word only 9 trees need to be removed. And so I think that's, emphasized by, saying that we need to preserve trees. FDOT roundabout feedback. 73% of public responses were positive after roundabout construction. Number one, that's like an appeal to authority, a fallacy, by saying FDOT endorsement without supplying any verifiable methodology or local relevancy. It's cherry picking. It's selective cities as a positive stat without a broader or contradictory data. And it's a hasty generalization. It assumes that success in other roundabouts meant that this one will be welcomed as well, but it's not welcomed by the people that still live on Nebraska Avenue today. There's still signs there today on Nebraska Avenue saying we don't want this project. Again, no anticipated tree impacts is what it says in the report, but yet that's a half-truth or selective disclosure. It admits that the overall project still removes trees, conveying the misleading impression that trees are safe across the board. I think that the warrant analysis disqualification for the stoplight, they say that a stoplight won't work just because it won't meet a warrant analysis. That's a false dilemma that implies that the roundabout is the only viable solution because others don't meet the merely defined standard. It's also an appeal to technicality. It leans on jargon, to shut down the public preferred alternatives without any way of explanation. And it also, begging the question, assumes the roundabout is needed to justify dismissing others, but the justification itself depends on choosing the roundabout. Just 3 more points. 75 crashes. Again, that's a fallacy of omission and suppressed evidence. It leaves out 2020, doesn't clarify how many were pedestrian-related or serious, and uses raw numbers without normalizing for traffic volume or comparing with similar corridors. And it also lacks context because it's a scare tactic to justify a premeditated solution. And it doesn't talk about the crashes around when a roundabout is in place of rear-end crashes and things like that. So it leaves out that. Roundabout has a proven history, reduces crashes, reduce speed, and work well with the county. Again, that's an overgeneralization, ignores the neighborhood dynamics, access concerns, and it even says that, that residents and drivers, may need time to adjust. So again, this assumes overall success based on unrelated locations, which glosses over the neighborhood-specific objections. And lastly, the speeding statistic. 15% of drivers go 6 miles over the speed limit. Again, that's a misleading statistic or a base rate fallacy because it does not say that 85% are within the speed limit. And how does it compare to similar roads? And it doesn't define how many drivers actually went over the speed limit or when it was measured. And I think this matters because it creates urgency without a comparative or absolute value and could be a standard or even better than average for similar roads. So, I'm against this project, and obviously would, go with the will of the board. But I just think this is a very misleading very just misleading presentation, and there's not community buy-in on Nebraska Avenue today. And I've gotten petitions from residents to stop this project, and so I still think there's a lot of work to be done. and that's just my feelings on it, Chair. And appeal to, the will of the board for, true discussion on this project. Thank you.
Okay. Commissioner Eggers?
Well, I think the presentation itself, the perspective, the historical perspective, and the rationale for consideration of the project, in general, are sound. I think one of the difficulties with a road like Nebraska is, and I don't know if there's, Tom or whoever, what the right-of-way here is, the width of the right-of-way on Nebraska versus what is actually appears to be the right-of-way. So, and again, saying that, it's going to be an adjustment when you take what is a right-of-way of decades, but it's really been reduced because of the, I don't know, if I were living there, I would use the right-of-way as well. So a lot of residents have gotten used to using the right-of-way along that area. That's just a fact. So when you try to make an adjustment, and originally, the flooding issue was embraced. So to say that people are against the project, I think they're against parts of the project, because I've talked to many of them myself. Many of them that are in favor of the project are a little quieter about it. But I mean, I think most everybody on there is excited about the flooding control aspect of the project. When I say excited, nobody's excited about new construction. You identified it's going to be a year-long project or whatever, so that's painful in itself. And after a while, we all get tired of construction. I get that. But I think the other piece here is in creating sidewalks on both sides of Nebraska. Is Nebraska considered a collector road? How do they define that in the transportation?
Yeah, it's a collector road.
Collector road. And I'm not saying that there aren't collector roads that have sidewalks only on one side. There are some of those, clearly. But the traffic counts here are pretty high. The number of, children activity, senior activity, I think, calls for sidewalks on both sides. I think the element that's changed also, if I remember, in the early going, it was more like a 10-foot wide sidewalk on the north side, in the sense of creating a kind of a trail extension, if you will, over to Westlake Village. Westlake Village, a major thoroughfare in Palm Harbor that connects Alderman to Nebraska. Lots of people there are excited about the connection piece. Trail-like, but not trail, because it's going to end up being 6 to 8 feet instead of that. I think originally was looked at 10 feet. So I think those aspects, I think I won't say all residents are completely happy with it, all of it, but a lot of folks are okay with it. I think even the folks on the north side, if it was like a regular sidewalk, like 5 feet, might be more But again, a lot of those folks, and I would have done the same thing, have utilized a lot of right-of-way for their property, whether it's landscaping or whatever. So it's going to be some changes through there for sure, and I don't diminish that at all. But again, when you take a look at a road and the changes you're making, we're not going to be coming back here for 40 years with major changes. Now, we may do repaving along the way. So you upgrade the road from what it is and what's being planned to, like, looking down the road. What's it going to be like in 20 more years or 30 more years, so that we can make sure that we're doing the right things or incorporating the right things in this project. Now, when we were looking at Alt 19 on the roundabout, I was all in, and we had a community that was really unhappy. I've heard personally no complaints until the other day when I made this statement. They said, well, I don't really like it. I said, okay, I got it. But for the most part, they've accepted that roundabout there, and I think it really works on so many fronts. We don't have a light at Nebraska because of the roundabout at Florida. The FDOT sold me, but I also agreed with the idea of a roundabout there. Less lights. So, as a sidebar, which has nothing to do with what we're talking about, they've decided to put a light at the post office, which is just like a stone's throw. I don't know if I could throw it that far, but to Tampa Road. So they argued against a light roundabout, and now we're putting another light in between the roundabout and Tampa Road. So they just got, I mean, to me, that just really has frustrated me. We are having meetings, well, anyway, we've had some discussions about the ongoing construction with that road right now, the improvements. But that's a different issue for a different day that I'm just, and I understand that there was discussions in FDOT about another roundabout at the post office, but because of right-of-way costs or access to a business that might create a problem, they decided not to go there. But again, I think to the point that was being made about selective thought process, depending on the argument, it's important to understand that, you know, one argument in one case doesn't always fit the other argument, or should the same discussion be brought forward. So I think there is some discrepancy based on the outcome that the intended, what we're trying to get done. So I don't like that at all on Alt 19. We're not talking Nebraska, but I still have not been convinced that a roundabout on Nebraska makes sense. We have a RRFB there. If that's not enough safety, there's the option of putting in, is it called a hawk system, which is instead of a yellow, it's a person goes up there and you hit the button and it actually goes red, yellow, green for crossing residents, you know, people. Yes. And it doesn't do it on every time you hit the button. So it has to reset and allow enough time for cars to clear, and the next person could be hitting the button and it's not going to change right away. But you could bring that red, yellow, green concept, even though it's, you know, it will be a little bit wider road through there, and not affect the neighbors, the four homes, still provide the safety to get kids across with that. Is it called a hawk? Tell me.
Yes.
Okay. I just think that option needs to be explored a little bit as it relates to that road. And I'm not sure I fully understand the tree canopy along Nebraska and how we're only talking about 9 trees being affected. So maybe we could see that. Is it really just the 9 trees that are being affected, being taken out? Sure. And kind of like, if I remember correctly, there's like a cluster of them is like 4 or 5 or 3 or 4 or whatever of the 9 that are being removed are together. But correct. I'd just like to maybe see that again, okay, to talk about the tree canopy issue. But I mean, I think the flood piece, I think the trail connection to a neighborhood that is to the west with the downtown, I think makes sense. And I think that's been narrowed from 10 feet down to 6 or 8 feet, depending on where it is along that north side, makes sense. But again, the roundabout and just understanding, the roundabout I don't get, I will tell you that one of our retiring assistant to the county administrators, and I would argue about this one all the time. I mean, she felt it was good. I did not. I still haven't seen that benefit yet. And then maybe a clearer understanding on the tree canopy removal for me.
Sure.
And those
Get
are my
that
comments,
information to you.
Mr. Chair. Thank you.
Remind me, Tom, what's the budget for this project? Do you know?
That I don't recall. Kelly, do you? Kelly's looking it up for us.
And the source of funds for this one?
Kelly's looking it up.
Okay. And then do we have any crash data before and after the current roundabout on Nebraska Avenue?
We certainly have the before. That just got installed within the last year, so typically they'd let it go for about 3 years and get a really good picture of what the crashes are doing.
Yeah, I mean, it would be, if we could maybe get a snapshot of that, maybe even at the 12-month time frame or so, just to just to have an understanding, you know, if it's, I mean, in my opinion, it moves traffic more effectively, but from a safety aspect, I mean, if there is in fact an improvement in safety, it would be good to know. And if there's not, it'd be good to know that too.
Yeah.
They could also provide other type of areas like this where you have more established data and use the mini roundabout for these neighborhood type examples.
Correct.
You could provide that.
Okay, sounds good. Okay, any other questions? Kelly's coming up here.
Just ballparking it, it's about $11.5, $12 million, and it's traffic impact fees and penny for Pinellas.
Got it, okay. Thank you very much. All right, if there's no other questions, thank you, Tom, thank you, Kelly. So I'm going to suggest that we bump the resiliency to another meeting, because we've still got to do agenda briefing, and then we've got security training at 1:30 to give us a little time for lunch, if that's okay with everybody. So, good? Okay. All right, so then, why don't we move on to agenda briefing, and we'll get that done, and then we'll break for lunch.
Okay, you got a couple of presentations to start off with. Under item number 4, you've got a map amendment, residential medium to office. This is in the city of St. Petersburg. 3 separate sites. 1 site's vacant. 2 sites include towers and access roads. So this it'll be a binding development agreement. Will allow a residential unit of 20 units on all 3 sites and restrict Site 2 to a maximum of 10,000 square feet of office space. Item number 5 is your short-term rental ordinance. I think you've been briefed one-on-one on that. Moving on over to item 15, this is our Ajax Construction Manager at Risk for our new county campus. So this is the corresponding piece to the design firm which you approved at the last meeting. And they'll be here, so you'll get to meet them also. Item 16, this is an affordable housing program recommendation for Independence Place. This is the zoning case from a year ago out on Park. Remember where we had to bring it back a couple of times?
Oh, right.
So this will provide for special need independent multifamily affordable housing apartments. You'll see that because you'll also see the cost is more expensive, and that's because of the types of the type of services being provided, and the different funding sources are listed within your packet.
Chair? Yeah, just, when I was looking at that, I talked with, Tom and Bruce, I had some concerns about that. And looking back at the, meeting minutes from, 23, I mean, it was a 4-3 vote to move forward with that project. 2 of the people voting for it no longer here. And so I'm just, and 338 people wrote petitions against the project. I mean, so, I don't know if it's maybe a presentation or something or more information about it, but, 4-3 vote, there's, some people here, dissenting with that. I don't know, it just seems like, maybe you should have more information on it, or, I don't know how I feel about it.
Well, we could provide that. I think the vote was on the zoning at that time, so this is the development project moving forward.
Yeah, if we could get some background information to all of us on that between
Okay.
now and Tuesday would be great, and then be ready for a presentation on it for Tuesday.
Okay. Item 17 is a donation from Duke Energy for pedestrian bridge at Rainieri Park. So it's a one-time charitable donation of $500,000, replaces an aging pedestrian bridge. And Duke will be here, and they want to give you a big foam check, that we'll try to cash and see how that works out. Item 18 is award of bid. This is a 26 pavement management preservation for package 4. Again, they're listed within your packets. Item 19 is a first amendment to an agreement. It's several different agreements. This is what Transportation Engineering Services uses. It's kind of like our JOC contracts where they use them on different projects. And so this increases the award based upon an extension of these agreements till September 9th of 2027. No, this is all pavement. Yeah, this is all repaving. Sunset Point, that's a paving job. Yes. Item 20 is an agreement with the City of Clearwater to provide funding to assist in the construction of a new fire station. This is the prorated share for our unincorporated piece. Item 21 transfers 3 ambulance bus assets to outside counties. So they were donated to us. We were trying to use them during hurricanes, and it really didn't work for us. And so we're transferring the asset out to some other counties for their use.
You thought you were safe.
Thank you. I would really like that. The Sunset Point Road repave is Keene all the way through 19 to McMullen Booth, looks like, that whole stretch. None of it east or west of Keene. That area is being looked at for a project, right, for widening and a middle turn lane and all that stuff. Okay, thank you. Sorry about that, I just wanted clarification. Better run, Kelly.
On to item number 22. This agreement is our annual agreement with Keep Pinellas Beautiful, adopt a program management services.
Chair? Yeah. Can we get a copy of the existing agreement? And like it seemed like in the agreement, they're responsible for getting like results every so often. So a copy of the current or previous agreement and the results per the agreement? Can we get copies of those?
Sure. Jill's taking notes, so she'll provide that.
Thank you.
Item 23 is an agreement with Seminole Electric Cooperative for the purchase and sale of electricity. So we sell to them when it's a better deal than when we sell to Duke. So it's at our option.
And this is at our WTE, right?
Yep, it's at the waste energy. Okay. Item 24 is our annual certificate for ad valorem assessment for the solid waste disposal and collection out at Lellman.
Sure.
Yep.
It looks like that's a 20% increase, and I don't know, there's not much kind of in the attachments on, why it's a 20% increase.
We actually did a presentation
we
to
had
the
a
commission
presentation
on this.
Yeah. We'll get you the presentation.
Yeah, I guess I probably wasn't for the increase at the time, so that's probably why.
It is. It's
Yeah.
a lot.
Yeah.
I mean, I don't think any of us really are, but
It's
just,
I mean, it's a bit amount, and we actually had to phase it in because of the increase. But it's the cost of the service that's provided.
well, if we could get them just for reference.
Resend out the presentation that we provided. Okay. Item 25 is a third amendment to a consent order with South Cross with the Florida Department of Environmental Protection. So there are several different things that they're updating within that. Jeremy would have to speak to it specifically if you have any questions. Item 26, a third amendment with Tire Technologies. This is our court case management system for an additional 36 months.
Under item number 27, this is a little bit different than what we normally bring to you. This has to do with waiver of a conflict from outside counsel. If you recall at the last meeting, I brought one in that was a specific waiver on a contract in place related to a separate contract than what's before you. The county recently entered into a contract with the firm that's referenced here to handle some negotiations with FDOT related to a utility relocation that's in conjunction with one of their projects. We retained outside counsel. Given some of the work that this firm has done with FDOT itself in representing FDOT in the past, they asked that we reduce the period within which the county can respond to a request for a waiver of conflict from 30 days, which is what normally exists in contracts, to 15 days. And the only way for us to accomplish that is what we're proposing here, which would be a delegation of what would otherwise be the board's authority to the chair for this one and only contract, not generally speaking, so that the conflict could be waived in conjunction with consulting with the county attorney's office, again, just for this particular contract. You all know that we're pretty stingy when it comes to recommending conflict waivers, so we felt like this was a good way to accomplish it. I did talk to the chair. He has a comfort level in speaking with my office about it. So again, we're recommending that you reduce it for this contract only from 30 days to 15 days. With the delegation, it will be, because that'll give us an opportunity to confer with the chair. What we were concerned about, you all have seen me, I will bring these things in under county attorney reports, but in those months where we only have one meeting, 30 days still wouldn't necessarily be enough time. So we thought 15 days was good, and also just giving for the 15 days they requested, we think that the delegation to the chair is the really only way to accomplish it. And we were comfortable with it in this circumstance, given that we're dealing with FDOT, and we had a level of comfort bringing this forward to you.
And so, just a question, why is it considered a outside conflict, a potential outside counsel conflict? Is that what we talk?
It's not unless and until the firm, the Shoemaker firm, unless and until perhaps a different office, a different lawyer within the firm might want to do some work for FDOT. So there's not a conflict currently. We're engaging them because of what we felt like was a need to.
And it wouldn't be on this project either?
Oh, no,
Okay.
it would be on a
So
different
it's just
project.
that they may be working way over here on a project.
This is a big firm, and they've got offices all over the place,
all right.
I think even outside of the state of Florida. So in this circumstance, we were comfortable asking for the delegation to the chair.
Thank you.
Suncoast Health Council.
Chair, on that, I just, I'm sure you're all reading the applications and resumes diligently, like myself. I just found it interesting in the, recommendations, they only list, one person has, HR experience, but the other applicant has over a decade of HR, health and human services, and was a Navy veteran, but yet that wasn't included in any of the notes. So I think in all of your consideration to take into consideration all the information, not just the edits and recommendations.
Okay.
Thank you.
Thank you. All right.
That's the agenda. The only thing I was just going to let you know is we just found out that our CDBG DR grant application has been approved. So the team, led obviously by Matt, but included so many other people purchasing, everybody else on our team. Nice. They've moved this at lightning speed. So now they'll be bringing back to you the recommendations regarding the firms, and so we'll move forward on that, but we'll be standing up these programs shortly. So.
Perfect. That's great. That is awesome. Okay. All right. Well, before we break for lunch, I just wanted to thank Deputy Winnick and Deputy Manley for keeping us safe here today. And also today, I believe, is officially Deputy Butterfield's last day.
Oh.
And we recognized him at our last meeting, and so we wish him a wonderful retirement. All right, with that, so we are adjourned, and we'll meet you back here at 1:30.